started, we're on.
Okay, we're
Okay,
ready.
great. Good morning. Welcome to today's court enforcement hearing. My name is Myrna Barushi. I'm going to be your special magistrate today. This is a quasi-judicial hearing, which means it's similar to court like we see on TV, or if anybody has actually attended to court. The difference is that the rules here are a lot less formal. Anybody who's going to be providing testimony this morning, I'm going to ask you to please stand up for the taking of the oath and raise your right hand. Do you swear from the testimony you're about to provide as the truth, the whole truth, and nothing but the truth? Okay, with that, I'll ask the town to please call the first case.
Okay, Madam Magistrate, first to be heard is our cases. The number one is Christine Brayrude. This is a parking citation that's going to be presented by Base Officer David Scott. Right here.
Hi,
Officer Scott, can you please state your full name for the record?
David Scott?
Are you employed by the town of Fort Myers Beach?
Yes.
And what's your position with the town?
Base officer?
And then as a base officer, is it your responsibility to enforce the town's parking regulations?
Yes.
Are you familiar with the circumstances that gave rise to this particular case involving Christine Brayard?
Yes.
Can you please tell the special magistrate how you're so familiar?
I was on Delmar Avenue checking parking, and I observed a white Jeep. The license plate was GGD81N, Minnesota license plate, parked in a non-parking spot in front of impeding the access to the dumpster on Delmar Avenue.
And was the car parked within the town right-of-way?
Yes.
And was it designated as a parking spot?
No.
Did you take photographs of the vehicle?
Yes, I did.
Are the photographs the ones that are in the file that's been provided to the special magistrate?
Yes.
Did you also take a photograph of the no parking sign at the entrances to the town of Fort Myers Beach?
Yes.
Are they also in the file?
Yes.
Did you issue a citation to this particular vehicle?
Yes, I did.
Upon issuing the citation, did the owner of the vehicle request a hearing concerning the matter here today?
Yes.
And the citation was issued for violation of what?
Not illegal space, code 28.20, 2R.
And if the special magistrate should find the vehicle owner to be in violation of the code, what would be the fine that's being proposed to be assessed?
It's a $50 fine with an administrative fee of $175.
Nothing further.
Do we have a respondent for this case? The owner of the vehicle? All right, I hereby find that the ticket was actually put on the car, correct?
Correct.
Okay. I hereby find that the violation as stated in that citation number. Oh, wait. What is the citation number? 7003395 did exist, and as such, I'm imposing the one-time fine of $50 and the fees and cost incurred by the town in bringing this matter before the magistrate in the amount of $75, which shall be due and payable within 30 days.
Thank you.
All right?
Thank you.
Thank you. Next one.
Next, we have Ashley Whalen. This is also a parking citation. The base officer presenting this case is Roxanne Tucci.
Morning,
Ms. Tucci, can you please state your name for the record?
Roxanne Tusi.
You never get it right.
Are you employed by the town of Fort Myers Beach?
Yes, I was a base Beach and Street enforcement officer.
Okay. And are you familiar with the citation 72664163 that we're here on today?
I am.
Can you please tell the special magistrate how you're so familiar?
I was working the shift that day whenever I walked up upon, it was on Ohio Street. I observed a vehicle parked along the roadway. About a third of the car was parked on the street. You can see on the pictures that I took. I then issued a citation for non-illegal, parking in non-illegal space. I placed it on the windshield. And it's a $50 citation. We have on each side of the island, it states you can't park on any of our roadways, so it was pretty well indicated on the signs, and also through the Florida Uniform Traffic Control Law, we have it also for no stopping, standing, and parking. So she was issued that person was issued a citation.
Did the vehicle owner request a hearing for today's date?
Yes.
Okay. And the photographs that are in the file that's been provided to the special magistrate show the vehicle in question, where it was parked and how it was on the right-of-way in violation of the code?
Yes, it is.
Okay. And you also provided a photograph of the no parking sign at the entrances of the town?
Yes, that's provided in the packet.
Nothing further.
All right, do we have somebody here on behalf of the vehicle owner? Coming up, state your name and relation to the case. You're gonna speak on this mic.
My full name is Ashley K. Elizabeth Whalen.
Okay, what's your response in reference to the allegations presented by the town?
So this was actually my first day starting work at Leaky Tiki Barbecue. I was unaware that I wasn't allowed to park there. The owner told me that I could park there. There's usually cars parked there in general, so I just naturally assumed, since they told me that it was okay, and since I didn't see, any no parking signs along the street, that it was okay. I haven't parked there since, obviously. But like I said, it was my first day of work, and I honest to God didn't know. I've now seen the sign on the front of the island that y'all are speaking about, but since I don't really go on the island until I started working there, I had no idea, you know what I mean? And there's no signs along the street anywhere about no parking. And, like I said, since it was my first day and my boss told me I could, I did.
Right, unfortunately, not having knowledge of the law is not an excuse. I'm sure you heard that before. All right, what is the town requesting?
The fine schedule is $50 fine plus the $175 administrative fee for the processing of all the paperwork and the scheduling of the hearing today with the special magistrate.
All right, I hereby find that based on the evidence presented, the violation in citation number 72664163 did exist, and as such, I'm imposing the $50 fine and $75 in fees and costs incurred by the city and bringing the matter before the magistrate. Due unpayable within 30 days. All right, thanks.
Okay, Madam Magistrate, next up is going to be number 4 on the new cases to be heard. The property owner is F&B Associates, LP. The case number is 20220321. The environmental projects manager presenting this case is Chad Schutz.
Good morning, Chad Schutz.
Mr. Schutz, can you please state your full name for the record?
Oh, I'm sorry, Chad needs to be sworn in.
Raise your right hand. Do you swear from the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You may proceed.
Mr. Schutz, can you please state your full name for the record?
Chad Daniel Schutz.
And are you employed by the town of Fort Myers Beach?
Yes, sir.
What is your, what do you do for the town and as an employee for the town?
Environmental project manager, code compliance, and project review.
And in that capacity, is it your responsibility to enforce the city's or the town's environmental regulations?
Yes, sir.
Does that include the regulations regarding activity taking place on the beach within the EC zoning district?
Yes, sir.
Are you familiar with the property located at 684 Estero Boulevard?
Yes, sir.
Can you please tell the special magistrate how you're so familiar with that particular piece of property and why we're here today?
Yes, sir. So, it was June 16th, the FWC Marine Turtle Permit holder gave me a call regarding a complaint that a berm of sand had been placed on the beach. Upon arriving, I observed a approximately 30-foot by 3-foot by 2-foot tall berm of sand placed in the wet sand. It appeared that the sand had been scraped from the upland dune, and witness verified that the tractor that is imaged in the record had scraped the sand and placed it out in the wet sand.
Did you have an opportunity to take any photographs of the activity that gave rise to the case here this morning?
Yes, sir. Those are the photos you see in the packet.
Okay.
I did put some outlines in there just because of the contrast, sand on sand, sometimes with the printouts.
Did you have an opportunity to have any communications with the upland property owner?
Yes, sir.
And did the upland property owner say that they in fact had done this work?
Yes, sir.
And is the, I guess, the front end loader that did the work, is it also, did you take a photograph of it?
Yes, sir. It's in the packet.
Okay. Did you have any, in your conversations or subsequent communications with the property owner, what did you advise the property owner would be the corrective action?
I believe we asked him to bring the sand back, and he declined that. We had possibly some subsequent conversations after receiving the notice of irreparable, irreversible damage, and a little bit down the line, we also had a meeting between the property owner, Lee County, and myself to discuss how can we make it right.
Can you, for the record, to make it clear, when did this violation take place?
When?
Yes.
June 16th, 2021.
And during that the subsequent time frame, which is excess of a year, you were, I'll use the word regularly, communicating with the property owner to bring this matter to a satisfactory conclusion without having a hearing today?
So we had a hearing scheduled in December? August. And whenever the notice of hearing went out for that previous hearing, the owner asked to meet, so that's the meeting I was describing before. And so we met and we continued the hearing on the contingency that they provide for mitigation for the impacts from the activity.
And it is the inability to bring that to a conclusion is the reason why we're here this morning?
Yes, sir.
Nothing further at this time.
I have a question. The neighboring properties, in addition to having the sand dunes, they have vegetation on them. Was there vegetation on this one? And if so, what happened, if you know?
It did look like a little bit of sea oats may have been impacted, but it was primarily the volume of sand that was the main impact. But there were some vegetative impacts. Having said that, there are stipulations in the Fort Myers Beach dune management document that allows them to rake fairly close to vegetation as kind of a quid pro quo for putting in vegetation at the last renourishment project. They can maintain that vegetation in place more or less in order for them, again, to, we want vegetation to be there, but we know that you don't want it to be sprawling, so you can maintain it there. But the primary concern was just the volume of sand that was donated back to the Gulf.
Now, the question, is it fixable?
So, after a tide cycle or two, it basically washed out. So, it was placed out there, and then it wasn't brought back within a short time frame. Therefore, the tide smoothed it out.
All right,
And
oh, go ahead.
I can just add that it was also sea turtle season, so just taking out, regrading sand during sea turtle season, even if there aren't any marked nests, is a concern.
All right, do we have somebody here on behalf of the property owners? Please come on up, state your name and relationship to the case, please.
Your Honor, Kaylee Tuck with Henderson Franklin for the record. On behalf of the property owners, Tim and Paul Malbon, they are here as well today if you have any factual questions for you. But I won't rehash what Mr. Schutz said, but I just wanted to kind of put out our take on the case. So they did meet with the property owners on August 24th, 2021, and that was after the hearing got continued. And at that point, we had never heard anything further. There was no reinspection to our knowledge. If there was a reinspection, there was no further notice of noncompliance. And Tim and Paul justifiably believed that they had handled everything. They made all requirements that the comments from the meeting that were said on that August 24th meeting. So they justifiably thought that they had complied. And they had heard nothing else until this new June 10th hearing of this year. So no new noncompliance notices, and in fact, while this is an unrelated case, Mr. Schutz did meet with the property owners on May 7th of a new violation, and in 4 business days, it was completely remedied. So Mr. Schutz did visit the property several times in between this last hearing and this hearing, and there was never any new violation, never any mention of the continued noncompliance. So I think what we have here is a miscommunication in what our side believes was the proper remedy and what the town believes is the proper remedy. So all we're asking for is some time to remedy the situation, and we're willing to do that. This has been a business in business for 32 years now, and they're an integral part of the community. They've never had any issues with code enforcement to this point. So that's all we're asking for is some time to fix it.
So when you say that work was done, what was done to remedy the situation?
And Tim and Paul can come up and explain exactly what happened.
You can call whichever witness you want.
Sounds good. Paul or Tim, either one.
Please state your name and relationship to the case.
Paul Malbon. I've been one of the owners of the Best Western since 1985.
So what work did you do after you got the citation?
What did I do after?
Yeah, once you got the citation and you were told that there was issues with the sand that was moved over and put on the beach, what steps did you take to try to remedy the situation?
Okay, the citation said that I had piled the sand up, but the reason behind my doing what I did was after a high tide, the beach gets washed flat, and then it slowly builds up a berm, and the water comes over that berm and leaves trash and standing water behind the berm. So after a fashion, the water keeps coming up and coming over, and then it cuts its own way back to the Gulf. So all I did was, where the water went back towards the Gulf, I filled that up so water would not come through it. And I left the sand mounted up high, and they complained about that. I took my tractor, I leveled it down smooth. Eve Haverfield came out, she looked at it, inspected it, said it was fine. At that point, the other issue was about some sandbags that we had used in a previous storm. We had stacked them on the side. The wind blown sand had covered them up. We have dug all of those bags up, dumped them back on the beach where they come from. They are no longer there. And that's the extent of it.
Is that what the town asked you to do, or is that what you chose to do?
That's what they asked me to do, yes.
So with regards to the sandbags, there were sandbags that whenever he scraped the sand, they became exposed. So, yes, to remove those
Well, the
sandbags.
sandbags right now, I don't see it as being part. My concern is mostly the dune that was basically moved about 10, 15 feet over. That's my concern right now. So that's why I'm trying to get, what was it that the town requested for them to do? And did they do what they were asked to do?
So we didn't request for anything specific in terms of mitigation. I asked, what can you do to mitigate for this? I did have suggestions, which would be to do an on-grade dune planting, which would mitigate some other issues they're having on the property. But I left it to them to come to us to suggest what the mitigation might be.
If I may, Madam Special Magistrate, we have had, you may recall that we've had similar type of cases in the past, whether it's for destruction of vegetation on the beach or some mangroves. And historically, and I certainly can ask Mr. Schutz to confirm this, is we ultimately enter into a mitigation agreement or plan with the property owner. And the testimony here, as I understand it, is, as I perceive it, is that that didn't take place. And that, at the end of the day, and when we issue notice of violation, which is in the file, we clearly state to the property owner, to the alleged violator, it's their responsibility to follow up with staff, because, we're not.
I get that.
Yeah,
The whole
so,
notion of you didn't show up to see if it was complied with.
Yeah.
You have to, if you have compliance, you have to call them to come out because they're not psychic to know.
Correct.
So obviously,
So-
so that part, obviously, I get. Where I'm trying to get at is, under typical situations like that, especially when we have the Department of Environmental Services involved, there obviously gets elevated, and there are specific requirements that the state is going to have for us, right, in the town to go ahead and repair it. It's not a matter of just go ahead and do whatever you want. There are certain things that have to be required, right? Correct?
Yes.
Okay, so my question is, did that happen in this particular case? And I know there's, the town will go ahead and provide the citation, say what the violation is, and it's gonna be up to the property owner to come into compliance. And to a good extent, the town doesn't have a duty to tell them exactly how to do it.
Right.
So it's a matter that it has to be compliant with case law, and especially in a situation like this one where we have the Department of Environmental Services involved. Again, that elevates it. That means we have to comply with what the state is requiring in addition to what the town is requiring. It seems that has not happened here. And when it comes to environmental issues, it's very concerning. Okay.
One final matter, we're not necessarily adverse, and in fact, the statute in our code provides for, providing the respondent with a reasonable period of time. All we're suggesting is that in determining what is a reasonable period of time, that the special magistrate take into consideration the length of that this case has been ongoing, and again, the respondent may disagree, the failure to follow up. And so that's all we're asking for at this point.
No, and I understand. It's like so it seems like the order, whatever order I enter here today, has to have a type of plan where there's a communication regarding what the mitigation is going to be, get the state involved if it has to rise to that level, so that everybody is in compliance and that beach can go back to the way it's supposed to be. So you understand that the beach, that cannot stay the way you have it right now, right?
So I think that may be a loaded question. There's been work done to the beach that we believe is in compliance as of right this minute. So that may be a loaded suggestion, but we're happy to comply with whatever the town's plan would be to bring it into whatever compliance it is.
Okay, let me go ahead and repeat myself. The town can't tell you exactly what they have to do because now you have the state involved. There's requirements from the town, there's requirement from the state. So it's not something that he can go out there and say, yeah, you can go ahead, whatever you did is fine. It's not gonna cut it, especially at this point. It's done, it has to be corrected. So I am trying to reconcile the fact that the mitigation plan was not done. It's been a year by having, do you understand that he can't use a tractor? Let's start there. He can't be using the tractor on the beach. I don't care if it's his. You don't do that, period. You're damaging the environment. You moved the dune, and then on top of that, you made matters worse by going ahead and taking the tractor again, and now trying to flatten what was there. That mean,
The mediation was never brought up in the original citation. Understand what I'm saying?
Okay, does he understand that he cannot use the tractor on the beach?
But he does have a vehicle on the beach permit, so,
Yeah.
for raking.
For raking.
But he testified he flattened it out.
Right, so that's different from regrading and placing the sand out in the wet sand.
Okay.
And because that sand, once it's gone or once it's flattened into the wet sand and there's no way to really bring it back.
And
So that's why I left it open to mitigate for the impacts.
All right, so have you been in communication at all with the state besides the initial?
With the marine permit turtle holder, yes. And with FDEP, they are aware. I don't know if they've done any compliance with this.
How do we find out if they are going to be involved in the mitigation process?
Well,
Or what the
so
extent of
for
the
them to mitigate, they would, depending on how they mitigate, they will need a CCCL permit to bring it into compliance. So that's where they would come in.
Okay. So the first approval has to come then from the Department of Environmental Services.
Once a plan is agreed upon, yes.
So that plan between the town and the owner has to come first, and then that plan will go ahead and go up to.
Get it permitted and authorized from the state, and then it can commence.
All right.
Madam Special Magistrate, my recollection, as fuzzy it is I think that then similar as you've either given 60 to 90 days for that process to complete itself, and then impose an appropriate fine if there's a failure to do so.
Because the concern is the time that it takes up.
Right.
Tallahassee. So that's exactly where I'm going to. Do we have any idea on how long those are taking now? Because the mitigation one, I mean, I can order it to be done in the next, to meet with you next week, before Friday of next week. So
Right,
that
so,
would be
an
have
on-grade-
conversations from the get-go.
Yeah, so something to the effect of an on-grade planting. My understanding is it could be field permittable, and that would be, 30 days to apply, 30 days to receive, something on that.
Madam, I'm sorry to, there's one final thing that we haven't discussed. Normally we do, which is what is it that the town is seeking in the way of fine potentially to impose here. Our concern is that the destruction to the beach dune that's taken place, it really never can get redone. So we are asking for a one-time imposition of a $5,000 fine if the special magistrate finds that there's a violation here.
No, I get it. The first thing I want to do is make sure that everybody leaves here, that this is going to happen, and this is our the time frames, get it done. So it seems we have 30 days to go ahead. Do they have to go, and I'm asking all these questions, normally I wouldn't put you on the spot with this, but I want to make sure that they don't come back and say, oh, well, they never told me. So is there any professionals they have to engage at this point in time to go ahead and be able to meet with the town to go ahead and come up with a mitigation plan?
If they felt the need to do a more elaborate mitigation than what I'm suggesting, possibly they would need either a landscape architect or something of that nature to restore the dune or restore the sand, if they wanted to bring sand in, but does that answer your question?
So if it's a simple mitigation.
It's a
then
simple
we-
mitigation. It's a matter of, 3 species of plants. This is the area we're gonna plant it. It's about the same area that you impacted, or that you made a berm. And that's just me.
What about the introduction of that sand dune? The reintroduction of that sand dune?
What do you mean by introduction of the
You
sand dune?
talked about vegetation, right?
Mm-hmm.
Wasn't there a sand dune?
So they remove sand, that sand is gone. It's in the ocean, maybe it's blown back or, whatever, but however, those impacts that they did, you're not going to be able to, once it's been flattened and into the Gulf, you're not going to get those grains of sand back. So I guess I'm not following.
Okay, there was sand dune there, right, in front of the house. It was further back, closer to the house. They had vegetation. The vegetation's gone, the sand dune's gone. Is the
But-
town gonna allow them to go ahead and just put vegetation and never put the sand dune back in?
Yes, that was my suggestion, would be an on-grade planting. They have other areas where if they, planted some vegetation that would mitigate other sea turtle issues they're having, where the sea turtles are laying nests at the base of their jet ski equipment. Again, this is just me trying to find something that's easy enough to do that helps another problem out and mitigates the impacts in a comparable way.
Okay, so, I think next Friday is the 8th, right? You're not on vacation next week, right?
Chad.
Sorry?
You're not on vacation next week, right?
Monday for sure.
My intent is to go ahead and order them to meet with you by Friday of next week.
Sure. Of next week.
That's why I make sure I don't want any prepaid plans or something like that.
Yes, ma'am.
Okay, so we'll do that. And then from there, the mitigation plan will be worked on. It'll get sent over to Tallahassee. Of course, that's their responsibility to go ahead and send it up there and follow through. So 30 days for review, 30 days for approval. And then the amount of work that would need to get done, at least based on what you're envisioning for the remedy, probably 15 days, is just planting. Alrighty, let me go ahead and come back to you. I've been asking a lot of questions over to the town. Do you have any questions, concerns, or anything of the like?
I don't believe so. Does that sound like
Pardon?
a good timeline? You said 30 days, 15 days?
To give,
Yeah, I'm not gonna be giving any more time, that I can tell you.
to give them an answer what we're willing to do, is that what it's saying?
No, it's gonna be for the mitigation.
Yeah, I guess.
Okay? I just want to make sure that we are in the forum. I don't want to hear that later on, oh, they didn't tell me this, they didn't tell me that, or, because I even asked the question about, well, do you need to bring a professional here? That's something that I shouldn't be asking the officer, but I did anyways, just to make sure that it gets done. Okay. Now, I'm going to address now the second part of it, which is the irreparable harm. I am going to tell you right, I haven't entered my order, but I concur with that there has been irreparable harm to the dune, especially with the conversation that we just had about whether we'll have to bring sand in, or is it just gonna be vegetation. What the town has at least presented here today as the quote-unquote solution is actually a mitigation more than anything else. That dune can't get back in there. It's just gone. So according to the Florida statutes, the fine for that irreparable harm is extremely high, and I'm inclined to grant it. Do you have any argument or reason why it shouldn't?
I did not take sand from the sand dune. It was a flat beach that I took the sand from. It was next to the sand dune, but I did not dig into that sand dune. They can take pictures from now till the end of time. I did not do it. I was the one that actually drove the tractor.
But I even heard you say that you flattened it out.
Pardon?
Flattened the sand out.
So he flattened the berm. So what he said, what he's describing is, so he scraped the beach, right, and took buckets of sand with a front loader and then placed it into the wet sand. So after a day or so, what he's saying is the FWC marine turtle permit holder, or he came and flattened it out in the wet sand. So the sand remained, the sand that he had taken from the beach into below mean high water, he flattened that out so there's no longer a berm, is my understanding, right, Mr. Paul?
No, I just made the berm consistent all the way across the beach. There was a hole washed through. All I did was fill up that hole.
Right.
Okay, so if that's the case, then what's the argument for the irreparable harm? I need to go ahead and be able to reconcile it, because on the one end, I'm hearing one thing, I'm going your route, and
So
then
you're
you
taking sand from above the mean high water line that, is part of the dune, adjacent to the dune. You're scraping sand from the beach and you're bringing it to below mean high water line, the mean high water line. So you're redistributing the sand.
The problem was the sand from the wet sand from the beach was moved over into the dry section, and then,
No, the sand on the dry section of the beach was moved to the wet section of the beach.
okay, so backwards, okay.
But as I understand there was, sometimes in these systems, there's what's called a blowout, where the water, and it's what I think how I hear him say is that what he did is he eliminated the blowout by removing everything that was on the sides. And that can never be put back. That, you know, whatever berm was there is now non-existent. And that's how he solved the problem that he identifies, that the berm was the problem, created a blowout, water was ponding behind the berm, and rather than
But that,
seal the blowout, he decided to remove everything else.
but that berm was,
No.
Well, that's what the photos show.
that's what I'm trying to reconcile, because I'm hearing one thing from him, one thing from you, one thing from me. I'm like all over the place. Okay, let's start with this. To the officer. The sand came from the side, not from the sand dune. So there was never a sand dune issue.
So there's a dune, I call it scraping the dune. There was some vegetation that was run over. It's, you know, a dune, it's not just a block, right? So it has a height and then it gradually goes. So whenever you're scraping the dune, you're kind of creating a hard edge along that dune. So that volume of sand that was along the, more or less like what we call perpendicular dune, it's not a frontal dune, but it was more of a perpendicular dune. So scraping along that perpendicular dune and bringing it out into the wet sand where the tide would normally come in. So if you want to go through the pictures, we can go through the pictures to better explain it, or
Let's go through the pictures.
so the one with the sandbags, I think would best explain whether you have the three pictures. If you like, I can bring up my copy to you.
Oh, you got it. Okay, got it.
So I tried to, you can see the red and the blue lines. So you know, this dune is kind of perpendicular to the shore rather than parallel. Does that make sense?
Yes.
So you can see that blue line where there's a line where he scraped along that dune where the sand kind of piles up because there's vegetation there. It's capturing sand, and you know, it has an elevation and it has a slope down. So he took a scrape along there and then took that sand from the upper beach and then placed it below the mean high water line into the wet sand.
So so my point is, if I look at the pictures where we can see the properties on the beach, looking at this one, right there, I can see the pink house, the yellow house, the green house, they all have that sand dune and the vegetation, right?
Right, so, but he does not have vegetation in front of his.
Correct.
And that is the maintenance configuration, that he doesn't have necessarily a dune in front of that particular portion of his property.
But there was a portion of that dune on his property that was plowed, moved over with a tractor.
Right,
So that's what I'm getting to. So the sand dune was impacted.
yes.
Okay, so in addition to
There
getting,
was elevation taken out of the beach. Elevation is a dune. It was scraped and put down into the wet sand.
correct, so in addition to moving it there, it sounds like there was other sand coming from the sides that was added to it to make the berm, I guess, bigger.
I don't know how he constructed it or what.
I think that's what he said, that it was like from the actual, because when I mentioned the dune, he said, no, I didn't take it from the dune, I took it from the area
Adjacent to the dune.
adjacent to where he put in the berm area.
Right.
Did I get that right, sir?
Yeah, I think so.
Okay, so I got it. So there was impact to that dune, while not a whole lot, because he didn't have a big portion of that dune on his section, he did impact the dune. Now, that was my question on whether that portion of his dune that he took, that he flowed over and moved the sand with, is that section, we talked about that he can just put vegetation just to fix it, he doesn't have to rebuild the sand portion on that dune. So talking about the sand dune,
So he didn't take out he didn't take out a lot of vegetation there, some minor impacts to vegetation there. Could he replant there? Yeah, that could be an acceptable form of mitigation.
so that's what I'm getting.
And
So
not
we have-
necessarily bring in sand.
So we have the vegetation, the town sounds like can do away with not having to put sand back into that sand dune. Vegetation will just kind of hold it together. And then the second concern, again, if I'm grasping it, at least coming from the city, I'll get back to him in a second, is the removal of the movement of sand from other locations on the beach into this berm, and which was constructed instead on the dry side, it actually impacted the wet side. Did I get that? At least from the town's perspective.
So he redistributed sand from the upper part of the beach to the lower part of the beach, the tidal zone.
Correct, in order to build that berm,
Yes,
because that berm wasn't there naturally.
Correct.
And it was not put by the town.
correct.
So he built that berm.
Yes, ma'am.
Okay, so, now, after the berm is done, he took the tractor and he redistributed the whole thing again. The sand,
I confirmed that with Mr. Paul. I didn't witness that, so,
he mentioned it, that's what he said, that he
Just
basically,
level it out.
yeah, he leveled it out.
right,
So he leveled it out.
that's my understanding.
Okay, so is there evidence that when he leveled it out, that the leveling out went towards, again, more sand onto the wet side where it shouldn't be, as opposed to putting it basically back to where it was originally?
Both ways.
Correct.
There, which one is it?
Well, he leveled it out where it was, not putting it back onto the upper beach.
So the berm, that's this photograph, the one right up there, he then came out and leveled that out.
I get that, but the question is, because the sand came, it sounds like the sand that which he used to build the berm, and again, I'll get to you in a second, came from both the dry side and the wet side.
No.
Just the dry,
Just the what?
just came from the dry side.
Just from the dry side, okay, so we have, okay, so perfect, so we now, let me go ahead and ask him this. When you distributed the sand back in place, did you distribute evenly, or did you try to put it back again into the dry side?
No, ma'am, that berm was a hole cut through the berm, and I just placed that sand up there and built actually a larger berm than what was there. And then I came back and smoothed it all over where the berm was continuous all the way across in front of us.
Okay. So here is where I'm having trouble with the argument from the town, is if the sand came from the dry side, and he got cited, the berm, he took the tractor, which again, I told him I don't like that part, but he went ahead and basically redistributed the sand back to where it was in its original location, with the exception that because there was a hole there, he got some sand in the hole to fill it. So I'm trying to reconcile now, where is the irreparable harm?
Again, you're taking sand, on the upper beach that provides, storm reduction impacts. It's part of that dune, and you're putting it into the wet sand where it's just going to be smoothed out into, he wanted to regrade the,
But the sand went back to where it was before.
no, ma'am.
Okay, so now that's a different story. So now explain to me what you saw that establishes that sand did not all go back to where it was before.
Okay, so
That's worthless.
it is worthless. So
Does it work over there, maybe?
No, yeah.
from here
Yes.
to here, and then just flattening it here, never going back up there.
Okay, do you have any pictures of the sand after it was redistributed?
I was not aware that he redistributed, or I wasn't aware that he flattened it out. I was under the impression that Tide had just taken care of it, and, I didn't realize he reworked it where it was in the wet sand.
But if I may,
Yeah.
Madam Specialist, the sand here is not really the violation. This is the end result of the violation. The violation was from here to here, this open spot, where he used that front end, that box cutter, that front end loader, to push the sand down that is, you see right here. This sand was up here. And he used it, and he scraped it down to push it down
No.
into this location. That's what the photographs show. That's what if you look at the northeast elevation photograph, the contour, it's where he scraped down the sand.
And we've been running in circles for a while,
Yeah.
because that's where it started. We got clarification from the officer that the impact to that sand dune was minimal. And I understand your concern that from the flat section, there was sand that brought out. I get that. But the testimony so far, and I have testimony here saying that he put it back to where it was, and the officer is telling me he didn't even know that it had gone ahead and he thought that the flattening was because of the tide, not because he had put it back in there.
He didn't put it back where it was. If you mean by put it back where it was, that would mean he put it back where that vegetation's at. He did not put it back where the vegetation's at. He kept it right there and smoothed it out.
But that's not the testimony he said.
Ask him again.
Yes, correct.
That's, go ahead and make your statement again as to what
That's
you did to
saying
fix it.
I did not push it or pull it. I took a front end, a bucket on my tractor, picked it up from back there in the dry white sand and dumped it right there in that hole. And then I came back. I don't know if y'all sent an e-vote or who sent her, but she came out and looked at it. She said, it's fine, don't worry about it.
Who was it, that person that you said that?
The turtle lady,
Eve Haverfield is the marine turtle permit holder.
Okay, did you talk to her recently in regards to the?
Recently, with regards to this, no, but I would, if I were going to speak for Miss Eve, I would.
That doesn't, I
Yeah,
understand
we
doesn't
were-
bring it into compliance. They had to call you to go ahead and do it. I
Right,
get
so
that. I'm
she
just
may
trying
say
to-
it's okay, but it's not something she wants done, especially during sea turtle season, to scrape the beach and.
So to understand what the position of the town is, I think it's best to look at the elevations, the picture. Can you put them up there?
So I understand the violation.
That's where it got pushed, and so the edge where you see all this plant material sticking up, and this is all through here, that's what we want restored.
And that's where I'm getting to. There's a statement from the homeowner saying that he put the sand back. I understand that the officer's position is that it was tied, but he even said, I thought it was tied. He had no knowledge about the homeowner actually trying to remedy the situation.
Tide's not gonna bring it back up to here.
And he's testifying that he did take it with his tractor. With his tractor, he went ahead and moved it up. Now, that's a
No, he
factual.
moved it down to the beach.
Ask him again to describe it.
In what direction did you take when you redistributed the sand, where did you take it?
You see the little cottage there? In
Yes.
that picture? The white sand in front of that cottage. I didn't scrape anything. I actually dug a hole with my tractor, carried the sand down there and dumped it where you see that pile of sand. And then I leveled everything up smooth. But the reason for that berm was the rest of the way across the whole property. I just made that part where the hole had cut through, where the water was coming through and filling up the whole area behind the dune.
I understand, but it's not relevant why you did it.
Okay.
For relevance of today is that you did it. So I get that. I get that you want to explain it away on it, but right now it's not about why you did it. It's the fact that you did it. What I'm trying to get at, okay. Part of my order is gonna definitely require for an officer to go out like ASAP, to go ahead and see what's going on. It can be next week, so I'm not gonna ruin your your long weekend. Because in order for there to be a mitigation plan and for me to be able to determine whether the violation continues to exist, somebody has to go out there and make that determination. Nobody from the town has actually been there. And again, I get it. They should have called you to go ahead and inspect it. And the reason I'm saying is that there's a possibility they may go out there and see the property and say, you know what, it's been corrected. And if it hasn't been corrected, the reason why, what else has to be done? Because, I mean, it sounds to me that we're pretty much now talking about sand, whether there needs to be sand replacement. Because we already addressed the dune part and the vegetation, right? So that sounds like a pretty simple fix. Now, the question is, if the concern is that there were amounts of sand that were removed improperly from the dry part, what's their solution?
If it's like for like, it would be bringing in that approximate volume of sand. But again, and that could be something that they suggest and I say yes or no.
Okay.
If you're asking me what I would prefer, something like an on-grade dune planting where they need a buffer because of, sea turtle, nesting sea turtle female issues before, that's what I would prefer. But if they're proposing to bring in sand, then that's something that, the town would entertain. But that would not be my first choice from an environmental perspective.
Okay, so but it is a fix. If
It
they
is a
bring the
fix.
sand. Okay. And again, that's contingent on somebody from the city, probably you, going out there and making that determination whether it needs to get the sand or not.
Going out there now, you're not. I mean, it's a year later. It's storms and storms later. There's nothing that's going to have necessarily evidence in the grade that you're not going to see this now. This is a year ago. You're not going to see any the slope has already been restored with how storms were.
That's what I'm trying to get to.
Okay.
It sounds to me, based on the evidence presented and the picture that we're looking at, yes, I understand that it was a year ago, but it seems like there's nothing for them to then correct, to come into compliance with, because whether it came to compliance because he moved the sand back, or because nature took its course and put it back in there, said, what is it that they need to do for compliance? Either that, or I'm really missing something.
Again, that's why it's irreparable and irreversible in my opinion, because if you take sand and you go and put it into the Gulf, and and he smooths it out and it gets washed over, are some of those grains of sand maybe coming back to that dune? Maybe, but it's not restoring that dune. The only thing that's restoring that dune is wind-blown sand from elsewhere and restoring that slope.
But when we started talking, you told me that your concern wasn't that dune, that the dune wasn't impacted.
I may have misspoken. So a dune is the elevation of sand. He
Correct.
obviously took out elevation, so the dune was impacted. I said the vegetation was minor. Impacts to vegetation was minor. A dune can be a dune with or without vegetation.
Correct.
Okay, so there were impacts to the elevation, which is what he scraped along that dune. However, and then put it, he took sand from A, put it at B, and then leveled it at B, and that's where it remains. So to bring it back to A, you can't do that anymore.
Let me ask you this, because it might be maybe the perspective on the pictures. Let's do this. Okay, going back to this one, to one with all the houses. We have the pink one, the yellow one, and the green one. We have the sand dune in front with the vegetation. We get to the two-story one, the white one, this one, that one right there. And there's a sand dune, and that sand dune kind of drops right in front of that house, right? Then you showed me the picture that had the blue line and the red line. I think it was the one with the one with the three pictures. The one with the three pictures. And now you have the blue line
Can't tell her.
of where that sand dune ends.
She doesn't feel that it's an irreparable harm.
The blue line, right?
What do you want me to do?
That's the line approximately at which he scraped sand to harvest it, to place it into the wet sand.
Okay. So how much of the sand dune was then impacted?
Approximately 30 feet by 3 feet by 2 feet, if you do the math. So, it's not an exact square of sand. So 30 times 2 is 60, times 3 is 180. Maybe if it's a kind of a triangle, maybe you're talking about 90 cubic yards. I don't know.
I want to go back to this one real quick, the one with the houses. In front of that white house, while there's no vegetation, is there a dune, even if it's smaller than the ones adjacent to it?
There was some, and that's what he scraped. I mean, it's part of the natural slope, and he scraped off that natural slope that came in front of the White House, yes.
So now that's why it looks flat, because it was a lower level sand dune in front of the property.
Yes, where those sandbags you see that are exposed, it used to have, I don't know, Mr. Paul, at least several inches of sand on top of those sandbags, and that's why they got exposed. So he took, a couple inches here, a few inches there, along the way, scraped it, harvested it, and then placed it into the wet sand.
Okay. Response.
the sand in front of that little cottage blows in there, and I have to,
I don't wanna hear, I don't wanna know about why you did it. I wanna know where the sand came from and where you put it back to.
okay? The sand blows in all of that area in front of that cottage, and it just keep encroaching upon the cottage. We have to keep it away from the cottage, or it would just keep building up. So that is the sand I took and put in that hole.
Okay, so it was sand from the dunes then?
That was not a dune, it was a flat beach.
Well, there's dunes on the one side, there's dunes on the other side, and there appears to be a small, well, looks flat now, a small level of that. Do we have a prior pictures or aerials or anything like that? You know what I'm gonna do? I'm gonna go ahead and table it so we can go ahead and get the rest of the people out here. In the meantime, if you could give me an aerial of the property prior to
Oh,
that.
oh,
I can get you an aerial.
Okay, so we're gonna go ahead and table it, so we can go ahead and keep moving with the rest of the audience, because we've been with this one for an hour now. And I wanna get these, the rest of the people out of here.
You're up next. so. Okay, Madam Magistrate, next on the list is number 5. Property owner is Tovar Jeffrey M. Trust for Jeffrey M., or TR for Jeffrey M. Tovar Trust. The case number is 20220351. The officer presenting this case is Chad Schutz. At the time, the town is requesting an order of violation, an immediate fine of $500, 30 days to remove the structure or submit appropriate zoning applications. If that is not done, a fine of $250 per day. If not in compliance within the 30 days, $150 admin fee, all to be paid within 30 days.
Mr. Schutz, you've been previously sworn in and identified yourself as an employee of the town of Fort Myers Beach. Is that correct?
Yes, sir.
And in that capacity, you're responsible for enforcing the town's environmental regulations. Is that correct?
Yes, sir.
Are you familiar with the property that is the subject of today's hearing at 8020 Estero Boulevard?
Yes, sir.
Can you please tell the special magistrate how you are familiar with this property?
Yes, I received a complaint that a structure had been constructed in the CWA, Critical Wildlife Area. I went out to inspect it and found that it did appear that a 30-foot bridge, if you will, had been constructed. Upon looking at that in the aerials and superimposing the boundaries of the CWA, it was determined that it was not in the CWA. It was actually landward of the CWA, which would be considered part of Mr. Tovar's property at 8020 Estero.
And that area is, what zoning designation does that area have?
It is environmentally critical zone.
And under that zoning designation, are structures of this nature permitted as of right?
No, sir, I believe they require a special exception.
Are you aware of any special exception application ever being submitted for and approved for the construction of this bridge?
No, sir.
Did you have an opportunity to have contact with the property owner after identifying this unpermitted structure?
I believe email correspondence. I don't believe I've spoken with him. There was some correspondence with, I believe, a lawyer of his from Illinois, and then Miss Thibault took over soon after that. And then I have had correspondence with her.
As of this date, again, have you reviewed the city's records for any building permits or special exception or any other approvals for this structure?
I'm not aware of any authorization from local, state, or federal agencies.
Nothing further at this time.
All right, do we have somebody here on behalf of the property owner? Coming up, state your name and relationship with the case, please.
Good morning, Madam Magistrate. My name is Amy Sarrazin-Thibault. I am an attorney with Pavis Law Firm. First and foremost, I would very much like to thank Mr. Schutz and Mr. Herron for their tremendous responsiveness and patience with us during this project. I think Mr. Schutz has given a very factual overview of the situation. There is quite a bit of detail that has come up since this has landed on my desk. So when this initially came to me, we believed that this was within the CWA. We believed that this was on state-owned lands. We began undertaking the work required to not only get the special exception so that we can pull building permits, but also to get authorizations from the state that would be required. Namely, we were thinking CCCL, but most importantly, we were thinking we would need an easement. After the first few months of work, DEP actually came back to us and said, we don't own this. So after some additional title work, we realized that his actual platted lot, when it was platted, that western boundary was platted to the mean high water line. So he's the riparian owner. Interestingly enough, because the CWA does not kind of cross over in front of his property, and because there was no erosion control line established, we realized that he is likely the owner up to the high water line. So that took some time to figure out. We have engaged Morris Depew, the planners and engineers, to help us with the special exception application. Both their office and mine has been in communication with staff regarding this. We've had some issues getting, I think we're on our 4th surveyor now, and 30 ecologists. However, it's DEP's contention that we are likely exempt from the CCCL permit, and because this is not state-owned lands, we won't need an easement. So really the approvals we're looking to get are the special exception so that we can then pull the building permit to retroactively permit the structure. I will also note, not that this takes away from the fact that there is, an issue with this. The property owner took title to this property in 2019. Based on aerials, this was in place. It was put in, I think, in 2015. Neighbors had told him that it was in place 15 years ago. That aerials have confirmed that that is not the case, but it was there before he bought the property. And you will notice if you zoom out, there's kind of a pathway that connects all of those properties so that they don't walk through the critical wildlife area, so that they don't disturb a very sensitive ecologically sensitive area. So we would like to keep the footbridge. We actually have our pre-app, now that we have the surveyor out doing work. All of my work is done, most of the planning work is done. We're just waiting on the survey. We have a pre-application meeting scheduled next Thursday at 10 a.m. with Chad. I believe Daphne will be there. I will hopefully be there. If not me, somebody from my office will be. So once we go through the pre-application meeting, get the survey finalized, we will be submitting for the special exception. So what we would really request here today is time to get the application in as soon as we get the survey back and can tweak the site plan however needed based on the survey. And then obviously go through the staff review process. I would assume that we will likely have at least one round of insufficiency, as we normally would in any zoning matter. And then of course the finding of sufficiency, time for notice to take it to hearing, and hopefully obtain approval for the special exception. So that is really what we are requesting today.
All right, so let me go ahead and,
I certainly don't have any disagreement with what's been stated, because obviously, town doesn't have necessarily firsthand knowledge with what the property owner has been through. The problem we have from the town's perspective, and I suspect maybe from the property owner's perspective as well, is that, again, this is a case that was started over a year ago. And while we are sympathetic and understand the various issues that the property owner may have, one, those issues have not necessarily been conveyed to the town, and we've not been kept abreast of what the issues are. So here we are over a year later, and we're in the same position from the town's perspective, admittedly, at the same place we were when the case first started. And so that's the issue. And whether or not that was there before, still doesn't mean that it wasn't built without a permit. And that's all we're asking for. Either a permit be obtained, or that process be well underway to compliance, or it be removed. And since no one's told us what's been going on, at this point, our request is that it be removed. Until the permits can be achieved. If it has to be rebuilt, then it has to be rebuilt. But at this point in time, the required permits at any level have not been obtained for it to stay there in its current location and its current configuration. And while we're sympathetic to the property owner, a year plus has gone by and we're no closer to resolution of whether this can stay there or not.
What is the city's position in regards to ownership of the land?
This is the first we've heard that this is.
I'm gonna
But we-
I have questions for her too.
But we have taken the position that this is the responsibility of the property owner. At one point in time, we were requested to actually confirm that one way or the other that it wasn't the city's. Because at one point in time, we received an email saying, well, this is the city's problem because it's on city property. We're like, okay, well, we'll go out there and remove it. Oh, no, that's not what we meant. And so we said, it's not on our property.
So, and that's where I'm getting to. It sounds like it's not the town's property. You spoke with DEP and they said it's not the state's property. Have you gotten anything in writing into that regards?
I believe I have an email somewhere that I can provide. I will say that particular issue, I believe, was communicated to the town. Again, this has been we recognize that this has been going on a long time, so, there are issues with that. We understand that the town is frustrated. We are frustrated as well. But I believe we did communicate that DEP's position was,
Well,
this is,
you can tell me DEP's
Right,
position until
right,
you turn
no.
blue. If we don't have something in writing
Right.
saying that it's not owned by the state, there's nothing that even they're gonna be able to do
Right.
because they're under the impression that DEP is gonna be involved.
well, and that's actually, so that's one of the issues that the survey is also intended to address. The survey that we have, that we will be submitting with our special exception application, would show who owns title to what in relation to the footbridge. So, and I believe as a requirement of the special exception application, we are required to provide a title certification, so that would, that's part of this as well. So, like I said, I believe I have something from DEP. I go on maternity leave tomorrow. So I will do my best to find that correspondence in writing and submit to the town before I go on maternity leave. And of course, the survey and the title certification would verify that as well.
All right, my next question is, why did they wait a whole year to go ahead and get the process running?
We have not waited a whole year to get the process running. So we have been in communication with the town. We engaged our first surveyor after we got word from DEP. So I believe we had engaged them in August.
But you said you heard from DEP when they told you that they don't own the property, or
Yes.
did DEP reach out and say, we can't do that?
No. When DEP said, we don't own this, and quite frankly, we think that this is likely exempt from the CCCL permit requirements, given the location, nature, and dimensions of the structure, they told us that they thought it was exempt. So then we went out, and took us a little bit, but we actually found a surveyor that was willing to work on this. After a few months, we realized that he was never going to come out and do this. So then we engaged another surveyor who then, for personal reasons, also backed out. So now the planners have a surveyor that I believe has been out to the property and has physically surveyed it. We're just waiting on the actual boundary survey document to submit the special exception application. Like I said, it has taken a long time. Any development project right now, quite frankly, you're looking at a very, very long time to find a surveyor. The property owner here was a victim of just poor circumstance when it came to the surveyors that we had tried to engage. We've quite frankly had the documents prepared for quite a while. I believe the first conversation that Morris Depew had with the town was maybe back in August or September of last year. So they have had discussions as well. Morris Depew and I have been working on this to the extent possible. It's just that there are things that planners and attorneys and town staff can't do. We need a Florida licensed surveyor. We need an ecologist. It's just been very, very bad luck trying to find somebody who is willing, quite frankly, to work on a residential property in this market and then actually holding them to that.
All right, so it sounds then, if you already had the surveyor out there and you're just waiting on the actual survey, that you have all your ducks in a row for that application. Is that the case?
Pretty much. I mean, we need that physical survey document. And then if there are any tweaks that need to be made to the site plan as a basis, based on that survey that we get back, those will have to be made, but our narrative is complete. Everything else is complete at this point. And like I said, we have our pre-app scheduled for next week.
Okay, so let's say that everything goes right. What does the property owner have in place in regards to obtaining that after the fact permit?
So we would have to submit for the special exception and obtain the special exception. Excuse me, sorry, I'm winded.
You can say it if you
I'm okay, thank you. We would have to obtain that special exception approval to be able to pull building permits.
No, I get that, but in
Yeah.
order to get building permits, you're gonna have to get drawings,
Oh, yeah.
and in the circumstances where you guys are, you probably wanna go ahead and have that ready to go,
Mm-hmm.
or at least the professionals lined up, so you can run with it and have it done, because it doesn't sound like it's big amount of drawings, but you're still gonna have to do some legwork. And I'd hate to go ahead and say, okay, I'm gonna give you 30 days, and you come back, well, now we have to get the drawings for the permit application.
I can verify with Morris Depew, but to the extent that the drawings that we have would not suffice for the building permits, I would hope that we could get them. I don't really know. I would say I would hope that we could get them back within a couple of weeks, but I don't want to promise something without talking to the people who actually do it to make sure that like they're not on vacation or something, and then the property owners.
That's okay, I'm gonna give you an order that you can show to them, and they'll get it done for you quick.
Okay, great.
All right. Application goes, let's say that she's got everything in line, she goes ahead and submits the application for the special exemption. How long, in your experience, would it take from, let's say she has it ready next week, which I'm not saying you can have it ready next week. Just say, let's say she has it ready for next week, she submits the application, how quickly would the process for her to get that exemption take?
3 months.
3 months?
3 months.
Yeah,
We're on break for a month, so it would have to go to the LPA, and then it would have to go to the council for approval.
So the staff is correct. When we say 3 months, we're factoring in that everyone, that the council and staff and the advisory boards go on hiatus essentially this month. Staff uses it to get caught up, and then we won't reconvene until August. And under our code, a special exception has to go before the local planning agency for advisory. They make a recommendation. They meet once a month. So we would potentially have that meeting in August if everything goes well. And then
That's gonna be even tougher.
yeah, that's going to be
Because
tight.
we've got, 7 projects before this one.
Yeah.
So we've got a lot of projects that are on the burner for the LPA, yes.
LPA meeting.
Yes, so it's likely it wouldn't get to the LPA until September, and then, because August is even pushing it at this point.
Now, you went out to the property, right?
Yes, ma'am.
Okay, I see the pictures, the boards look pretty recent. Were they in the process of fixing it, and that's where the problem was discovered, or was it just one of those?
Right, so this was a new structure. There was a previous structure there. So this is 2018, 2019, you can see a previous bridge or whatever that is, a board. It was described to me as a board to traverse the tidal flow there. And then you can see from 2019 to from 2020 to 2021, there was a more substantial structure was built. And then I also have something to add with regards to permitting. I know Ms. Tebow had said that this would meet an exception, but I'm not aware of any exception that this would meet for FDEP. I think this would be something that would require a authorization via permit.
Well, that's one of the, yeah, that's what I'm gonna, one of the requirements is, first step is she needs to go ahead and provide you with the documentation from DEP in writing that this is not owned by the state, and hence DEP is not involved in any way.
Whether it's owned or not, it would still,
May
because of its
require.
location, likely require either a verification of exemption or a proper permit.
Before they go to the application process with the town, or
Yeah,
after?
we would need something in writing, either an approval from FDEP or an exemption letter from FDEP saying that it's not subject to their permitting authority.
Exactly, which was what I requested for her
Yeah.
to provide, because she says she has something to.
Furthermore, there's, we cannot guarantee that the special exception will receive a favorable recommendation or get approved by the town council.
I think the issue, going ahead and assuming that everything that you said about the DEP and the federal land is not gonna come into it, that is just a matter of the town. It sounds like we're looking at a 3-month period, from soup to nuts.
Likely, at a
And then
minimum.
Just assuming that
yes.
everything goes well, like you
Yes.
said, like assuming.
At
that
a minimum.
everything goes well. Okay, my next question is, in one of the pictures. Okay. In the picture that you have, that one, the 3, it looks like the, oh my God, I'm moving up. The planks that were placed in the first one and the third one, do you know whether it was intended to stay that way, or whether it was just under construction and they didn't finish it? And there's a reason for the question.
So this seems like there was the final construction. I mean, I didn't monitor to see if they added anything else, but I haven't seen anything change since.
Now, I heard the city attorney hinting towards that the town would like to go ahead and have this removed until the whole process goes through.
My 99% recollection is that at one point in time, either through direct communications with opposing counsel or maybe by email, I suggested that until the matter was resolved, in order to not have the code case move forward, is that the both ends of the structure either be permanently blocked off or removed, because that's the problem, is that it is currently being used and it doesn't have a permit, and there's all kinds of issues with that. And so our staff's thought process, as I conveyed to the council, was don't use it, remove it, make some modification to the structure so that it is not usable, because that in of itself creates health, safety, welfare issues of an unpermitted structure.
And I see that concern on that. That should be a pretty simple remedy. Okay, so let's assume, and by the way, that's where I'm inclining, and for the owner to block it, if that's something.
And we can barricade it.
Yeah, that's something that
Well,
it's easy for you
that's
guys to
fine.
do, and
We'll
it
barricade it.
makes the town happy with it.
Okay.
To go ahead and have it barricaded. We do the, how much then, 3 months and 4 months for, given that there's backup on?
I would suggest that perhaps within 4 to 6 weeks, or 4 weeks, relatively soon, they have the application in.
Well, that I'm gonna order,
Yeah, I mean, once it's in and we're reviewing it, as long as the application, a complete application is submitted. Because I can't say if it's gonna happen in August, I'd have to look at my development order projects. So,
I just wanna know for when the timeframe for the order, that's what I'm trying to.
I mean, I'd say within 3 months that we can get it on the calendar to hear the special exception for the first LPA.
For in 3 months to hear it, or 3 months to heard and over? Because when I asked the question, it sounded like you were a little concerned about the backlog.
Well, like I said, this is assuming that we have an LPA and then it goes right away to council. I don't know how I don't know how the town manager is going to be putting the agendas together for the town council. It could be 2 town council meetings out, so I can't really determine that part of it so much.
I have
You see what I'm saying?
a recommendation that might
Yeah.
be helpful. We would be amenable, obviously, to X time to submit the application and then Y time to aim for that hearing, but recognizing that there may be delays to get to the LPA because of other projects that are first in line, we would be open to some sort of condition where, we're making sure that we're communicating with town with some relative frequency. Maybe it's a weekly update between the town and the applicant, and then to the extent an
Your
extension.
purposes, it'd be easy because I'm gonna order you to go ahead and submit the application probably within 30 days.
Right, and we're great with that.
Once the application is in,
Right.
all your client has to do is keep the walkway blocked off.
Right.
That's it, because then the town will go ahead and take care of that. Do we have when our next meeting is gonna be scheduled for?
I'm hoping for August. I was going to say perhaps we do a status update in front of you
That's what
for
I'm
August.
thinking about, so that I can go ahead and, my clinician right now is do 3 months, application within 30 days, and then we can do the status, I'll do 3 months with a status conference in August to see where they're at. And then in August, we can decide whether we keep it as is with the 3-month, allocating 3-month process, or you can come back and report, no, they're way too backlogged, they won't be able to get into that one. But by then, the application will be in, and at least it's not a speculation
Limbo,
about things, we
right.
actually have something running. Okay, now, my last question, let me not say that, but I'm hoping it's my last question. I heard a request for $500, what's the reason behind the $500? As opposed to the statutory $250?
This has just been gone on a year. I'm going to tell you what's happened, and this is going on across the town. You're going to see cases, there's 2 or 3 more, where we have tried to work with people, we've continued, this is the second time, or this has already been continued once. This is an incredible amount of staff time, just to even put it back on the agenda and create your folder and all of that stuff. At some point in time, we have to curb this. I would like to see fines, so if you are gonna lead us on and let us believe that you are really working to compliance, because we do grant continuances, but if it gets out of hand and we finally have to come here because you have not followed through, I believe that there should be a monetary fine for
I don't
that.
have a problem with the one-time
Yeah,
fine. My
that's what I'm
question
saying.
is the 500, because the statute only allows me to go up to 250.
Then $250.
So that's why I wanted to know if there was something
Yes.
else that I wasn't aware of.
No.
I agree. with
Okay,
what you said.
then
I don't
$250.
have a problem with the one-time.
Okay.
Okay. All right, anything else? All right, I'm ready to issue my ruling. All right, I hereby find that the violations as stated in the notice of violation did exist and continue to exist. I'm hereby ordering the property owner to submit the special exception application within 30 days. Block off the pathway within 10 days. And I'm gonna go ahead and grant an additional 30 days. I'm sorry, an additional 3 months
Thank you.
for the review process, for the exemption. With a status hearing for the August hearing, I don't know what that date is, but when we do the order, if you could get that and put it in.
Just do next hearing?
Yeah, the August 2022, the August one. Status on that one. I am granting the town's request in the amount of $250 for the one-time fine. I'm granting the city's request in amount $75 as incurred by the city in bringing this matter before the magistrate. And I thought there was something else. And we gotta do the per diem.
Special Magistrate, we're just trying to confirm, so we want to make sure that we all understand that if any of these timeframes aren't met,
Yeah, I'm gonna do that. The
is a fine going to, yeah, okay,
That's where I'm heading.
okay. All right,
So I'm seeing, per diem. All right, so failure to go ahead and comply with any of those deadlines is gonna, including the appearance in that August meeting, is gonna result in, $250 a day until the violation is fully corrected.
Understood.
And that's, the one-time fine and the fees and cost is due within 30 days.
And that, so I know the fine is $250, and then the fees and costs were?
75.
75, great, so 30 days, wonderful, thank you.
Within 30 days. And then, 30 days for your application, then 3 months, block off within 10 days, and I'm gonna have an officer go out there on day 11 to go ahead and confirm that it's there, and then do surprise visits every once in a while when he's in the area, to go ahead and check on it, to make sure that it stays that way. And then the 3-month period for the review with the status on August, okay?
Thank you very much, Madam
Alrighty,
Magistrate.
thank you. You'll get the actual order in the mail. Thank you.
Okay. Madam Magistrate, number 6, Lonnie Kai, at this time, we received a letter from them yesterday or day before stating that they had fixed the issues, so I'm not gonna say that they are compliant. I would like to continue this until we can get an inspector out there to inspect it. So this will be continued.
Continues granted, okay.
Okay, so number 7 is gonna be Prasad Properties. Oh, I'm sorry.
did we have the aerial photograph to go back to number 4?
No, but he's been here testifying.
Oh,
Oh, what?
okay,
He just went back in. He was just testifying all this time.
all right.
Is it, did you say an hour? Is that what you're looking for?
What do you mean an hour?
No, that we had already been dealing with it for an hour when she.
Oh,
continued
okay.
He was
Okay.
asking about the air. I was like, he's been here for an hour.
You're right.
Testifying on this one.
Do you want me
Yeah.
to go on to?
Yeah,
the
no,
next
move
one?
on to
Yeah, I'm
Prasad,
sorry.
7, yeah.
Okay. So number 7, Prasad Properties, Florida Investments LLC. The code officer presenting this case is Bill Stout, is case number 20220655. The violation is a violation of LDC Section 14.5, beach furniture and equipment. This is a repeat violation of beach chair rental without equipment. The town is going to request an order of violation, immediate compliance, again, immediately cease rental of beach chairs as you ordered previously. We started this, notice of violation went out on February 14th. February 14th to today is 126 days, and if you have 126 days at 500 per day, is $63,000, and with an admin fee of $150 to be paid within 30 days.
Also, Madam Special Magistrate, just to, although we're going to present, for all practical purposes, the cases together, but there are 2 separate cases because, as you may recall, the property has a split address and strap number. So with that said, Officer Stout, can you please state your name for the record?
Bill Stout.
And are you employed by the town of Fort Myers Beach?
Yes, I am.
In what capacity?
I'm a code compliance officer.
Are you familiar with the property that's subject to today's hearing at, let's give both, 1046 and 1028 Estero Boulevard?
Yes, I am.
Just so for the record, what is that location commonly known as?
It's a Sunset Grill
Is it a restaurant?
in parking lot, yes.
Are you also familiar with the fact that this property has been the subject of a prior code cases on both properties for the same violation in the past?
Yes, it has.
Did you testify at those hearings?
Yes, I did.
What was the outcome of those hearings?
The town was awarded their request.
Okay. Which was the property owner was found in violation, is that correct?
Yes, he does not have a permit for having beach chairs and umbrellas for rent or to even be on the beach.
So please tell the special magistrate how you're familiar with this property and essentially why we're back here on a repeat violation.
Well, actually, beginning after we got our ruling on the last time and had the order, we decided to continue to monitor because he was informed that part of that order was to come in compliance. We've continued to monitor the property, and we have, since town staff has obtained photos on a regular basis, not every day, but on a random basis. I am the one who takes most of those pictures, and so I visit the property on a very regular basis for the last, I believe it was March, was when we got, March of '21 was when we got our last order. So I'm very familiar with the property.
And during your visits and your photographs or your documentation is set forth in the file, what did you observe?
Except for weather issues, the beach chairs and umbrellas are available.
Okay. Do you recall that at the last hearing, the property owner made the assertion that these chairs were only being made available to patrons to his restaurant, and essentially there was a quid pro quo, or an exchange for renting or having or using one of the chairs or the umbrellas in exchange for having to purchase food and drink. Do you remember that?
Yes, I do.
And do you recall back then, at that hearing, that your testimony was that that was not the case?
Yes, we had evidence to the contrary, that you actually did have to pay a separate fee to sit in one of the chairs and have an umbrella.
And during the current case and your observations of the chairs and umbrellas being rented, did you see the same, essentially the same thing take place? And in other words, it was not any type of arrangement. People were renting the chairs and the umbrellas separate and distinct from any activity or association with the restaurant.
That is the case. I have seen that. We have seen the attendant who sometimes he'll drill a hole to put in the umbrella, typically has a leather pouch that has funds in it, and we've seen him put funds in that leather pouch. And that scenario has not changed.
Okay. And on the days that that are alleged in the notice of violation, do you observe those activities taking place?
I can't say which days, but there are, if you look at some of these other photos, you will see that there are pictures of an attendant. He testified at the last hearing. His name is George. And there's one photo where he actually flashes the money to us.
There is a sign in the photographs that you've posted that has been placed into the sand near what appears to be a movable counter on the beach. Are you familiar with those photographs?
Yes, that movable counter is primarily used for the parasail business.
Okay.
Okay, so the attendant there. But the other sign, if you're requesting, is a sign, I believe, regarding alcohol.
Yeah.
Yep, and that has been put there by the property owner to indicate to people you cannot bring alcohol coolers or your own beverages onto his property.
But this is public beach, is it not?
There is a fine line between that. He does, to my knowledge, behind the restaurant, have ownership X number of feet from the structure, but I do not know that distance.
Okay. And the photographs that are in the file that have been presented to the special magistrate accurately represent the condition and of the property on the dates they were taken, consistent with your testimony here today.
Yes, yes. I have approximately 200 more photos, if they were needed, from beginning of March of '21 to yesterday, June 29th.
Any communications with the property owner or any of the employees regarding this issue since the last hearing? Between you?
Not really. I mean, I've talked to Terry here and there.
Terry being
Terry Prasad.
the owner of the property?
Yes.
And substance of those conversations, germane or relate to the seating?
My conversation with Mr. Prasad has been that he is not charging money to rent the chairs. He's not denying that the chairs and umbrellas are on the beach. His only account has been that he is not charging for them.
A couple questions. Under the code, as it currently exists, is it are you required to have a permit in order to be able to have this type of use on the beach?
Yes,
Have you determined or reviewed the town's records to determine whether or not a permit has been issued for this property location for that type of use?
yes, and a permit has not been issued,
Okay. Has one ever been applied for?
not to my knowledge.
Nothing further at this time. We do reserve the right to recall rebuttal witnesses.
All right, do we have somebody here on behalf of the property owner? Someone up? State your name and relationship to the case. And for purposes of the record, there was a request for a continuance as to this case and the other two for the same property owner, and I issued an order denying the motion for continuance. So thank you for being here.
Sarah Spector with Retzel and Andrews on behalf of the property owner. Speaking to that continuance, can I ask one question since there was actually 4 cases? I see that the 4th was continued. I wasn't aware of that until I saw the agenda today. I don't know when it's continued until.
It is consistent, Special Magistrate, because there's a 4th case that was also the request for the motion for continuance. Both parties set forth their reasons. We have confirmed that's the case that deals with the stairwell that was open to access to the general public, that the stairwell has been blocked off, so it does not present the issue, the health safety issue that we were concerned about and set forth in our response. And my understanding is that a permit application has also been submitted yesterday to do the repair work. So assuming a permit is issued, then the work and the case would proceed under that. Obviously, if they do the work, then the case goes away. So it is, at this point in time, we don't see any reason why the case should be continued for more than 30 days. That's more than enough time, in staff's opinion, for the work to be completed.
Yeah, and that was the reason, I think that's the one that your letter said, that it was just seeking, that you believe that it was already complied with, that you just did the inspection. The reason that I didn't grant the continuance on that one is because I wanted to be here. I'll issue an order, or go ahead and ordering an officer to go out there and inspect it in regards to compliance. But I'm hearing now that there's the second part of the permit. You'd still have time anyways to do it. It's not I'm gonna go ahead and find you on that one, because if you're from the city, from the town, it seems like you're moving forward, so it's.
I just wanted to know how long
Yeah.
we had.
Yeah,
30 days.
if the work is not progressing
It'll be back. It'll
and
be
being
brought.
completed, it'll be back most likely the August hearing date.
Yeah, and it wasn't, I don't believe it is in the agenda anyways today, was it in the?
It is. It says continued, and I didn't know what
Oh,
that
okay.
meant, so that's why I was asking.
That's why. And,
Yeah.
and when I denied the continuance, it was for that purpose, because I wanted you to show up so that I could go ahead and request the city to send somebody out there and give you the time to go ahead and close it out.
Got it.
Okay. So they did it before me.
Okay, perfect. May I
Do we-
please?
Give me just a second. Do we want to do an order on that continuance about the 30-day? Or,
I think that from a practical standpoint, staff has
Wanna
pulled
leave
it
it
from
alone?
the agenda.
perfect. I just wanted to make sure that
Yeah.
she got she said, that she was informed.
Yes, thank you. May I please
Okay.
approach to provide you with some exhibits?
Yes, whatever you want to show, and please show the city attorney
I
first.
have copies for everyone.
Oh, fantastic, thank you. Thank you.
Thank you.
Thank you.
Somebody else need a copy of them? Okay. Since it has been a minute, I will remind you that I'm Sarah Spector with Retzel and Andrews. I am here on behalf of the applicant, and I just did want to confirm, because my exhibits pertain to both cases, both 1028 and 1046. So are we hearing these cases together? Is that?
They keep them separate as case numbers, but you can argue them together.
Okay.
Because it's a technicality, it's two folios, same property, same two folios.
Madam Special Magistrate, for the record, I object to the admission of these exhibits, subject to determination how they're relevant, and Special Magistrate determining that they are relevant. I can state the reasons why I object on the relevancy issue for the
I see
record.
where you're going, let me go ahead and give her a little bit of
Okay.
leeway, because she might be able to tie it. So
I will.
I'm gonna give her the opportunity to make her argument.
Thank you. That's why I provided it. Okay, so to start off with, the one thing that I want to make clear is that the town has historically recognized Mr. Prasad's right to serve alcohol on the beach. This dates back to 1974, and this was again confirmed by the town in 2014. You can look at Exhibit A.
That hasn't been disputed. The issue is the umbrellas, not the alcohol.
It was disputed when I spoke to Mr. Herron yesterday, so that's why I wanted to establish
So
that.
we're here on the issue with the permits, with the beach and the chairs and the.
I, just so the record is clear, when I had my conversation with Ms. Spector, I specifically said exactly what the special magistrate said, which is the issue of alcohol is not relevant, in our opinion, to this matter, and that's why we object to its relevancy of the admission of these documents. We're not here on whether or not Mr. Prasad has the right to sell alcohol on a portion of the beach that is adjacent to his restaurant. That matter has been adjudicated by the courts, and we have abided by that. The issue and the sole issue for the special magistrate for consider here today is the issue of the commercial use of unpermitted rentals of chairs and umbrellas by Mr. Prasad.
And
Nothing
if you'll
more,
give me a
nothing
moment,
less.
I'll tie all of this in.
Go ahead.
It is relevant
Go ahead.
to my point. So the one thing that I wanted to show you, and I appreciate that the town does not contest it. I thought, I don't know if I misunderstood that yesterday, but the one thing I do want to show you is on the last page of Exhibit A, there's a premises map. And you'll see that the premises extends quite some ways all the way to the Gulf of Mexico, being identified as the premises.
And we do object, and I have stated to Ms. Spector that that was submitted and put in by Mr. Prasad, and that the previous approvals for the top of the mast that was the subject of the alcoholic beverage issue show a much smaller area that was approved by the state and by the town for the sale of alcohol.
Exhibit A is the application that was submitted by Top of Mast. You can see on the last page of Exhibit A that it was stamped Top of Mast and the business name was Top of Mast.
This is not the complete application.
The reason I'm showing you this page, if you'll please let me continue, is the fact that the town signed off on the premises. The town, you'll also see,
Right, let me see where, if you're thinking, if where you're trying to get to is to try to tell me that Mr. Prasad has the right to go ahead and do whatever he wants to do with that beach section, because by law, in this 2014 case, there has been a finding that that is his property and he can do with it whatever he wants.
not exactly, but what I am trying to establish here is somewhat what you're stating, and that's, he does have the right to serve his customers, whether it be food or alcohol.
Nobody's disputing that.
Okay,
The issue is the.
no, I understand that. Mr. Herron keeps objecting. He told me yesterday he objects to this,
Well,
so
he's
that's
the
why.
youngest magistrate I am, and I'm telling you already 3 times. The issue is not the alcohol or the food, the issue is the
Right, okay.
umbrellas and the chairs.
So, right, so the first reason I'm introducing this is first to show that it's been treated as one premises, as was mentioned at the beginning, and again, when I,
The one premises. You're telling me now that he owns the beach?
yes, his property line extends to the mean high water line. And so what I'm saying, yes, he has permission from Alcoholic Beverages and Tobacco to serve there, and he has permission by ownership to serve there. His
It's
customer.
not the service of alcohol and food is not the issue.
It is the issue, because in order to be able to serve his patrons, they need somewhere to sit.
That's not the problem. The problem is that he's renting them.
which I'm getting to, he is not. And that's what what I would like to present to you with these exhibits. So, so the first thing I was going to ask for is recognition that this is essentially one premises and that you consolidate the code cases so that there's one.
They're two separate properties. I understand that if you look at it, it looks like one building. They're two separate folios. We've been dealing with this for a long time.
I understand, and I appreciate the opportunity to be able to speak here again today, because this is my first time here.
I understand that, and that might be the problem. It is your first time dealing with this particular case. This case has been before me on several occasions with the same issue. So I'm very, 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 very familiar
I understand.
with the actual evidence and testimony in reference to at least the previous ones. So I'm giving you a lot of leeway here, but if you tell me again that he has the right to go ahead and sell alcohol and food again, and you don't address the issue with the beach chairs and the umbrellas, I'm just gonna enter my order.
I understand, I just haven't been able to get to my point yet.
Go ahead.
Thank you. So if you look to Exhibit C, you can disregard Exhibit B since we've already established that. Exhibit C are the pictures that we've taken, and you'll see here, if I can walk you through them. The first one, you'll see that there's a sign posted on the restaurant that says no beach rentals. The second picture, you'll see a server who's actually bringing a drink out to a customer on the beach. Mr. Prasad actually employs servers that work just in the beach area to serve the customers that are on the beach. And there's just several pictures here because none of the town pictures show you that there's actually people being served on the beach. So I've provided those pictures so that you can see. And also just see that they only put out enough chairs to be able to serve the customers that are there that day. So that's what's being demonstrated by these pictures, is that they have drinks from the restaurant, they're being served from the restaurant, they have food from the restaurant. So the next thing I wanted to point to you is Exhibit D, and this gets to the heart of the matter. The heart of the matter is he or is he not charging people for the chairs? Exhibit D that I've presented to you is a form that each person that uses those chairs is required to sign. It specifically provides that the chairs are not for rent. There is, and Mr. Prasad admits to this, that because it takes extra staff to staff the beach, because not only is there staff that needs to go out there to serve, there's staff that needs to go out, put the umbrellas out, put the chairs out, so that because they do have to come in at the end of the day regardless, they don't keep them out, and they only put them out when they're used. So he does charge a service fee. When they pay their service fee, they fill out this form to say they understand they're a patron of the restaurant. They're given a wristband. If they do not have a wristband, they're asked to leave the area because Mr. Prasad is very cognizant of his his liability based on his insurance, and does not want anybody other than patrons on his beach. So he's taken a great deal of caution in making sure that he knows who is on the beach. I did not see much from the town with regard to the evidence that they have. I know that statement was made that they've seen transactions taking place. I'm assuming those transactions are the ones that are shown in Exhibit E. These are from the town's file, and I think this is where the code enforcement officer was mentioning that he was flashing his money. First of all, this is George, as Mr. Stout had indicated. George is the longtime, I think he's been there for 10 years, as the parking attendant. What he does is often they have regulars that will come before the restaurant opens, and he will go to them to.
Madam Special Magistrate, I'm sorry, but just for the record, and I very rarely like to interrupt, but we're talking about hearsay upon hearsay. I know the rules of evidence are relaxed, but.
Let her finish, let her
Okay.
finish. I know where you're going, let her finish. Go ahead.
Thank you. No evidence was presented other than a statement, so I'm left to believe that these are the pictures that are being relied upon, so I wanted to explain them. George is the parking attendant, so of course he has money. In the second picture, you'll see he has his pouch that Code Enforcement Officer Stout referred to. That's his parking money pouch. What happened in these pictures, and I apologize, George is not available today because we were hoping for a continuance and he has to work, so we didn't get to cover his shift. But what is happening in this picture, and I'm sorry, I forget his name because I haven't dealt with him before. There was Nello. Nello Cernoia was a previous code enforcement officer. He asked George to pose for this picture. He asked him to show his money. George is developmentally disabled and will do what he is told to do. So the fact that these are the only evidence I've seen of this violation, I can't, if there's other evidence to consider, when I spoke to Mr. Herron yesterday, he indicated that there would be additional witnesses here that have actually gone to the beach, have gone and have paid without having to purchase anything at the restaurant. That, I didn't see that presented today, so obviously there aren't.
And we have a rebuttal witness to the other side's case as they're presenting it. We'll get to that.
He was physically, he testified he was physically there on several days and he observed the transactions happening.
And can I ask
You're
a
more
question?
than welcome to cross-examine.
Are these the pictures that you're talking about? The picture up there?
I
Or
have-
are there other?
As I stated earlier, I have approximately 200 pictures over the last 15, 17 months. And there's multiple pictures of George walking around with his money. He wasn't posing for me. He didn't even see me.
I looked through all of the pictures that are in the file. These are the only ones that I found with money changing hands. We're talking about this violation today.
He was physically there.
That's physically there. I saw.
He's been physically there on multiple times. He stated that. And he observed the exchange of money for the beach chairs and the umbrellas without involvement of food or drinks. And we've dealt with this with Mr. Prasad for a long time. This is not the first time this comes up. And I understand it's the first time here, welcome, but it has been a consistent issue that the town has been dealing with, and he refuses to go ahead and acknowledge it or remedy it.
Because it's our assertion that there's no violation.
And I understand that you're the attorney, and I appreciate you going ahead and being a zealous advocate for your client, but the evidence presented, your argument does not counter the evidence of first-hand account of what was happening on multiple days.
Well, money is changing hands. They're selling food and beverage.
He saw no beverage or drinks, beverage or food exchanged.
And that's why I was
They know what they're looking for because this is not the first time the issue has come up. So they already know their method of operation on how it works. So all they have to do is just pop in every once in a while, and there it is.
And that's why I was explaining what George is doing with the money here. He's the parking attendant. So, and I didn't get to finish my statement previously, was they have regulars that come to the beach before the restaurant and the parking lot opens. So George will approach those regulars to collect their money for parking because he knows who they are. And in the second picture, there's not even anything, there's no one in the picture for him to be exchanging money with. So I understand there's 200 pictures in some file, but this is a new violation. And I've not seen anything pertaining to this particular violation. There's liens on the others. Those have been dealt with. Those are separate. I've not seen anything in this file that shows that money's changing hands.
Testified.
He said he saw
Personal
George.
knowledge.
He said he saw George with money without food.
And
He's-
he saw a whole bunch of other things to the extent he took 200 pictures of them. He can't even produce 100 pictures for you today. He saw it with his own eyes. He was physically there.
But if these are the pictures that he saw.
It doesn't matter what the pictures are. I can have 0 pictures, and right now his testimony goes uncontroverted.
But this money is not for the chairs. This is for parking.
And
Okay, I'm running in circles here. Okay, so what is the city requesting? The 126 days out of violation at the repeat violation of $500
yes, ma'am.
rate.
I
Okay.
mean, you know, we will proffer into the record the rebuttal testimony of employee Kristen Schumacher.
And I would like to reserve the option to.
And she'd have, certainly, on that specific issue. So, Ms. Schumacher, can you please state your name for the record?
Kristen Schumacher.
And are you employed by the town of Fort Myers Beach?
Yes.
Are you familiar with this property?
Yes.
Are you familiar with the issue that's being discussed here today?
Yes.
Did you have opportunity to visit the property in question and rent a chair from an umbrella from the owner or employees of the establishment?
Yes.
On what day?
June 25th.
Were you ever asked or told that your rental was in conjunction with the operation of the restaurant and use and consumption of food or beverages?
No.
Nothing further.
When you said June 25th, was that 2022?
2022.
Okay, thank you.
Alrighty, I hereby find that the violations as stated in the notice of violation did exist, that this is a repeat violation, and as such, my order is to comply for immediate compliance. The property was first cited 126 days ago, and there has been testimony from and evidence presented from the town in regards to the activities being done therein in reference to the rental of the chairs and the umbrellas. As such, I'm gonna go ahead and enter that order for $500 a day on the basis that it's a repeat violator for that 126 days, totaling $63,000, and I'm also granting the city's request for the fees and costs incurred in the city in bringing this matter before the magistrate, and I'm gonna do the $75. Those are payable within 30 days.
Ms. Magistrate, may I ask the witness one more question?
No,
I
I've
understand.
already ruled.
Okay, thank you.
Thank you. All right, so, the next one,
Yes, Madam Special Magistrate. Again, the respondent is Prasad Properties Florida Investments LLC.
This is a violation of a special exception with the resolution number 20-8 of the Section 4 conditions. The code officer, it's going to be a zoning officer, presenting this is going to be Eli Lee. At the time, the town is requesting an order of violation. The notice of violation allowed for 30 days for compliance. No compliance was made. In accordance with the special exception, the town is requesting $500 per day per incident after the 30 days allowed in the notice of violation. The notice of violation was issued on 1/10/2022. If you add the 30 days plus 5 days for mail time, it's 2/15. 2/15/2022 to 6/30/2022 is 135 days. 135 days times 500 per day, which is what the resolution of the special exception called for. It is also 9 conditions times the $67,500, which would be $607,500. The town is requesting that fine, $607,500, and to bring this within compliance within 30 days, or an additional fine of $500 per day per incident, which is in accordance with the resolution of approval.
okay, let me go ahead and
Uh,
give you more information on this. Go ahead.
Officer Eli Lee, can you please, Eli Lee, can you please state your full name? Can you state your full name for the record?
Eli Lee,
You're employed by the town of Fort Myers Beach, is that correct?
Yes.
In what capacity?
as the zoning officer planner.
And in that capacity, you're responsible for reviewing and assisting code enforcement and town staff in implementing and enforcing town council development approvals?
Yes.
Are you familiar with this particular piece of property?
Yes.
Are you familiar with the particular special exception and conditions that were granted to the owner of this property? And that's the subject of today's hearing.
Yes.
And where's that property located at, for the record?
1046 Star Boulevard.
What's there?
It's an empty parking lot, people park their cars there.
Under the code of Fort Myers Beach, is a special exception required in that area of the town in order to operate what I would characterize as a commercial parking lot?
Yes.
And that was the subject of the resolution that is here before us today.
That's correct.
So the property owner applied for that special exception?
Yes.
Went through the entire public hearing process, including before the town council?
Correct.
And did the town council, in fact, grant him a special exception,
Yes.
but
Conditions.
with conditions? And in addition to the granting of the special exception, didn't the town council also grant him a series of variances?
Yes.
So he would be able to have this use there?
Yes.
Okay. Has the property owner complied with any of the conditions of approval that are set forth in the resolution?
No.
Have you had any communications with the property owner or his representatives concerning implementation of these conditions?
About this particular property, no.
Has the property owner approached the town at any point in time that you are aware of regarding the special exception approval and the conditions of approval?
Not to my knowledge, no.
Have you reviewed the town's records to see whether or not any amendment to the special exception has ever been filed?
No.
Nothing further.
Okay. I have questions. Do I have the actual,
The resolution?
Resolution?
Yeah,
I'm still reading, oh, I got it.
okay, it should be in file.
Got it.
So, just by way of background, Special Magistrate, and Ms. Spector can correct me if she understands the facts different than what I'm gonna, just to refresh everyone's memory. This parking lot and the parking use has also been before the Special Magistrate on a number of different occasions. And during the course of at least one of those public hearings, staff informed the property owner, Mr. Prasad, and it's done so separately, but I do recall during the public hearing, during the Special Magistrate public hearing process, that he could apply for a special exception to legalize this use. And lo and behold, Mr. Prasad decided, yeah, okay, I'll do that. And applied for, went through the public hearing process. The LPA, the Land Planning Advisory Board, made a recommendation of approval with some suggested modifications to the conditions of approval. It then went before the town council, and the town council accepted some of the recommendations of the LPA and rejected some and went with the original staff report recommendations. And to the extent that it's necessary, we can and will submit into the record copies of links to both the LPA hearing and to the town council hearing. But at the end of the day, the resolution before you, which is in part of the file and being entered into evidence, is the codification of that hour-plus public hearing before the town council.
Okay, now, we're talking now about the
Just the parking lot.
parking lot. Now, refresh my recollection again. Was it the issue that it was being used as a commercial parking lot and the town agreed to go ahead and allow him for a variance so he could get his permit so he could use it as a commercial?
Correct. So, and some of the other violations that were also the subject of the conditions was your Honor may recall that we brought before you a code violation pertaining to the dumpster. and the dispute whether or not it had gotten properly permitted and it needed an enclosure. And those are all set forth in the conditions of approval.
Okay,
So
so,
the intent through that approval was to resolve all these code violations as it related to the parking lot.
so the motion. The resolution that I have in front of me, oh, never mind, it's back here. 14 conditions, right? Is that,
That's correct.
okay. So we have 14 conditions on the resolution, and then I'm looking at our notice of violation. It has 12.
There was two in there that wasn't kind of applicable with the notice of violation, I put those that was in violation. The 12 that's in the notice of violation are the 12 that's from the town resolution that currently is not in compliance.
If you look at number 1 and number 14, they're not actual conditions. So
And 14.
14 is just the fine,
Provision.
Okay,
yeah,
okay.
and
Got it.
so
That's
there are
where the
actually
500
12,
come from.
yes.
And that was some ordinance. So it sounds then the only one that was complied with was the hours of operation?
Yes, from my, investigation.
All right. Is there anything else from the city at this time?
No.
Okay, let me go ahead and hear from council. Say your name again for the record.
Sarah Spector with Retzel and Andrus on behalf of Prasad Properties.
Okay?
I don't think I heard it from Mr. Herron. If he did state this, I apologize, but Mr. Prasad has met with the mayor and with the town manager about going in and amending the special exception, and would like to meet with them before, for, I guess, lack of a better term, a pre-application, before submitting that, to make sure what he's asking for has the town's blessing. And we're asking for additional time to get that, but during the time while he's getting that, he will operate it as a single-use parking lot for just Sunset Grill, understanding that he'll still need to charge a service fee to the patrons of Sunset Grill, just to offset the cost of operating the parking lot.
And the question is, if that was Mr. Prasad's plan, and the violation came in January, why are we here in June, and no arrangements have been made for anything to happen, either to come into compliance with the correct the violations, or have that meeting if that's what his intents were?
He's been meeting with them to date, he just hasn't been able to set the final meeting before submitting the application.
So you're telling me that he's had formal meetings with the town to go ahead and address this?
That's my understanding, but with the manager and the mayor, so I don't know, I don't have dates of those meetings.
Allowed you to speak, yeah.
Again,
Okay. Yeah, go ahead.
objection for the record, hearsay.
It's allowed, but go ahead.
Yeah,
I'm sure you-
and the town's response is, that's not true. Again, the manager he's here, and we can bring him in if necessary to testify, but
It
the
wouldn't
hearsay
even
exception
matter
has been accepted, so I'm here stating on behalf of the town that the representations by Mr. Prasad and his representative is not consistent with ours. Town staff just yesterday spoke to the mayor, and he said that was not the case. So, I mean, the bottom line is that this has
doesn't
gone on
matter. It's
for
irrelevant.
over a couple of years, and he just needs to file something.
Honestly, whether they met or not is irrelevant. I just want to give you the opportunity to respond. Because right now, as you can imagine, there is a resolution that is in place. It hasn't been amended. And
understand.
that's it. So, it's either he complied with it or he didn't. Sounds like he didn't. I'm not hearing anything from you saying otherwise. All right, what is the city requesting?
As set forth by the,
Kinda,
there's a
the cheat sheet, yeah.
Yeah.
cover sheet that we provided to you that
You did, here. Okay, and
Ms. Saunders
Daphne.
testified to. So we would ask that the special magistrate find that there's a separate violation for each of the conditions that have been cited for noncompliance, and assess the fine as set forth in the resolution of $500 for each of those violations for the time frame from the date that the resolution was entered to today's hearing date. I believe that's
$600.
$607,500 plus the $150 admin fee.
We were only given one notice of violation.
With all the, conditions that were violated listed.
They weren't issued as separate violations.
They don't have to do separate notice of violation for each
It
one.
wasn't identified as separate violations for purposes of a
These
fine.
items are a violation of the following town codes. I'm looking at it right here, and they're listed.
Right, but there's no mention of a separate fine for each violation.
And here it says, violation of conditions of approval shall result in a $500 per day per incident. Each one of those itemized items being an incident.
I don't-
Read 14. All right, I hereby find that the violation as stated in the notice of violation did exist and continues to exist. I'm hereby granting we're doing this one as, yeah, it's a new notice. I'm hereby granting the city's request that fines be imposed since February 15th of 2022 at the rate of $500 a day per each of the violations. That's running for 135 days, and that's totaling $67,500. Wait, hold on. Never mind, I did that all wrong. Let me start again. I hereby find that the violations as stated in the notice of violation did exist and continue to exist. That the property owners were notified as of February 15th of 2020. From 2015 of 2020 to June 30th of 2020, there have been 135 days. At 135 days times $500 a day, that's $67,500. And then it gets multiplied by the 9 incidents for a total of $607,500, which will be my fine. And it'll continue to accrue in accordance with paragraph 14 of the resolution, which requires the $500 per day per incident for any continued violations. I'm also granting the city's request in the amount of $75 in fees and costs incurred in bringing this matter before the magistrate. And, yeah, it's immediate compliance, so it'll continue to accrue at that rate of the $500 per day per incident. Okay. All right, thank you.
Madam Magistrate, at this time, would you like to recall the FNB Associates?
No, let's go ahead and get these people out of here.
Okay,
They've been very patient.
all right. So we're moving on to number 11,
Off we went.
which is going to be First Baptist Church of Fort Myers Beach. Case number is 20220414, a violation of section 342351, recreational vehicle subdivisions and recreational vehicle parks. They were using the parking lot as a camping site. The code officer is going to be James Campbell. At this time, the town is requesting the payment of the 6 citations that are in this code case of $2,750. We would like an order of violation. We would like for the respondent to immediately cease operation of an RV park. And we would like to ask for $75 admin fee to be paid within 30 days.
Okay. Or do we, go ahead.
Officer Campbell,
Was you sworn in?
Yes, I've been
Oh.
sworn in.
please state your name for the record.
James Campbell?
And are you employed by the town of Fort Myers Beach?
Yes, sir.
In what capacity?
Code enforcement officer?
And in that capacity, is it your responsibility to inspect and determine whether the properties are in compliance with the town's codes and regulations?
Yes, it is.
Are you familiar with the property that's located at 110, 138 Connecticut Street?
Yes, I am.
And is that the First Baptist Church of Fort Myers
Yes, it
Beach?
is.
Sorry.
Yes.
How are you so familiar with that property? Described to the special magistrate.
It first came to my attention on April 25th. Got an email from I always forget his name, Norbert, complaining about RVs parked in their parking lot overnight, people camping out. I went there the next day, saw it. I actually gave him a warning first time on April 27th for the violation, and also attached to it was the statute or the ordinance for the violation. Like, could we go by each one of these? The warning, then citation, each one that separately?
No, you issued how many citations?
I think it was 6 total,
And for each occasion?
each for the same thing, correct. And I do have photos for each one of the citations, and they're numbered on here.
And the photographs accurately reflect the condition of the property and the time that you visited?
Correct.
Please tell tell the special magistrate a little bit, what do those photos reflect?
If you want to go to page 5, there's the first one is a van there, staying overnight. That was taken by Norbert, complaining about RV parking. I have another photo, actually, if I can get these in order. Oh my God, so many photos. There's actually a really good one on page 19, if you want to go there. There's an RV parked there, and obviously you can tell someone's staying inside because the light's on. In this, oops, I'm sorry.
Why don't you go, instead of jumping, why don't you go sequentially through
Each ticket?
each, and the presentation that's part of the special magistrate's package? So you can
All right.
cover everything that you believe you need to cover, including the photographs and the information indicating that the property owner is in fact publicly, advertising this for this particular use.
I went over the warning on April 27th. The sworn affidavit being delivered. There's also one of our coworkers, Kristen, found on a website, says Beach Baptist. They do a harvest host, which shows that they allow people to come camp on their grounds. And if you go to page 13, it'll actually show the sign on their property advertising it. It says harvest. Underneath, you can see it says host.
No, ask them. So tell her about this one. This is the website that tells them what it is.
And then page 14, there's one that says RV camping, like wineries, breweries, farms, and attractions. That one's linked to the Harvest Host,
That is their website.
which is their website, the Harvest Host. And then if you go to page 15, it actually shows the parking for Harvest Host on there. The designated parking spots for them.
Officer Campbell,
Yes, I keep going.
did you have, as part of your investigation of this case, did you take a look at the towns and Lee County's historical records to see whether or not this particular use was ever permitted?
It has never been permitted.
Okay, and you determined that after reviewing the counties and the city, and the town's files and database?
Correct.
Okay.
And I've also talked to a few people who are familiar with the Baptist Church.
Okay. Who were those people?
One of them was Christian Schumacher.
She's also a town employee?
Yes, she is.
Who else?
That's probably the only one I've had the most contact with on this case.
Okay. And ultimately, the end results of your investigation and documentation were the issuance of the citations that are part of the file?
Correct.
Did you have an opportunity to make contact with the property owner or the property owner's representatives?
Yes, I have.
And can you please tell the special magistrate what those conversations were, to the extent that they are relevant to today's presentation and hearing?
The first time I spoke to them, it was actually the receptionist when I dropped off the warning. And that was back on April 27th of this year. And the second time I spoke to anybody was the gentleman here, who actually came here and requested me, and we spoke about some of the citations and the problems that occurred because of this.
So
And us-
we understand, we're making full disclosure. It is possible that these types of uses can be permitted. Is that a fair statement? And then I'll follow up with a question. No.
I'd have to ask, no,
Without
believe-
zoning. Okay, so the point we're trying to make is that as currently configured, as currently permitted, current site plans, and not correct that this is not a permitted use.
Correct.
And in order to be able to become a permitted use, assuming it could be permitted, the property owner would have to go through the process of amending their site plan, potentially getting the property rezoned, and going through all the procedures and processes in order to be able to do this, conduct this particular use on the property.
Correct.
So it is possible.
I'm sure if.
In theory,
In
it is.
theory,
In theory, it is
yes,
it is
in theory,
possible.
yes.
So long as certain requirements are met, it is an option available, potentially.
Yes.
Okay.
And the reason I say that is that, I know that town staff, including myself, have had past communications with the property owner, not Mr. Kritzer, but I believe his son, met with Mr. Green, who's appeared before you as the head of the Community Development Department, and myself, to talk about what is permitted and what isn't permitted on the site, and what would have to take place in order to be able to allow what they would like to do at this site. And I can't tell you what happened afterward.
So the talks did happen, and they were provided the possibilities if they meet X, Y, and
That's
Z.
correct.
Got it. Okay.
But otherwise, the position of the town is that what was approved by Lee County prior, because this was prior to incorporation and subsequently when the town contracted with Lee County to perform some of its permitting functions for the town for a period of years, is whatever is approved on their site plan is what they can do. Anything else would have to go through whatever process, including potentially rezoning, to be able to allow it as a permitted use.
And when you were talking about what's allowed in the site, on the site plan, you were basing it off what Lee County had already approved, which is what stands right now, correct? Okay. I think I got it.
Nothing further.
All right. I believe we have somebody here on behalf of the property owner coming up. State your name and relationship to the case.
Thank you, Madam Magistrate. My name is Forrest Kritzer. For a better title, I guess, I'm one of the pastors there.
Okay.
My son is the pastor, and he would have been here, but due to illness and in the hospital, he could not make it. And then our associate pastor, she also is in the hospital. One's in Lexington, one was in Tulane or Orlando.
It's okay.
Yeah.
It's okay.
Yeah, in Tulane. So then I got elected.
Okay.
So I have some comments, okay, and state my case, please, for the record. And I don't know that we need this. I had the resolution that he has applied to for the county, where they made the resolution that we could do what we could do on the property. And we do, the violation stated that we have a recreational vehicle subdivision or a recreational vehicle park. That's what it says. Now, as soon as the violation came to us, our associate pastor, Malik Kritzer, came up here and talked to individuals and took the advertising site down because we didn't know that we were not in compliance, but we got in compliance as far as the advertisement is concerned. We got another code violation that said that something about the advertisement was still up on the internet. And so I came in to the town myself because I wanted to get, because that's my granddaughter. And so I wanted to talk to him personally. And I did. And he said, I said, it was taken down the day that you wrote us the code violation. And he says, no, sir, it's not. It's still up. I says, unbelievable. So he brought me his phone and he showed me the violation where it was on the website, but that is not for the RVs. We have a 63-bed retreat center on the property also that we do advertise for a deposit, and church groups rent that out for different meetings, whatever they do. That was the advertisement that he showed me on his phone about the advertisement. Now, Harvest Host, yes, we were contacted by them. It's a free, it is not for hire. You don't charge for people to come. It's there for a sanctuary for people who are traveling from point A to point B and they can't get into a campground because of state parks are booked up or Red Coconut is full. And so we gave them a place to park overnight to sleep. Now, there was some of those pictures are vehicles that are not a part of that original, that he didn't know that, okay? Like one of them belongs to one of our church members, that brown van with the air top on it, and it's been there for over a year. And we move it around to mow grass or whatever you have, but no one has ever stayed or slept in that particular van that belongs to an individual. And we did have, after he sent us that deceased order, I would call it, we took the site down, and we took we had a Harvest Host sign right there in the grass by the trees where you're willing to park. We had a minimum of how many that we could accommodate, which was 5 on that parking area. We don't want an RV park. You know, we don't have time, and you've been involved in a lot. I can hear you've had already today, but I'll give you one indication, well, 2 indications. One was people from Germany. They were stranded. They had no place to go. And so we gave them a place on the church parking lot. We had a mother and a daughter and a grandson that were traveling in not what I would go across country in an RV. It was rough. But they were mourning the loss of her husband, her son, and the father of the child. We meet people like this all the time, you know, coming through, and we get to talk to them and counsel with them. I know that's not the issue, but I'm telling you, the people that we are helping are not affluent. Some of those vehicles that come in, we've had some $250,000, $300,000 vehicles come through there, you know, but we had it out there for free, so they do. Now, I'll grant you that in the underneath where we have the showers and the bathrooms, I put a box up there, and I put it down there: Harvest Host and guest donation, not required. We do not charge a penny for somebody to stay on our lot. Now, I was told, hearsay, that the code enforcement person was talking to someone and said, first thing, I know they were sleeping in there because I saw them and I took their picture. He's on our property looking into somebody else's window at night, sleeping, and taking a picture. That's unheard of. I mean, I don't see how that could be legal, but that's an invasion of privacy. Then they tell me that, well, you can't have people sleeping in cars on your property either overnight. We have people who are displaced on this island, and they can't afford a place. And they work in the restaurants around here, but they can't afford a place to live. We gave them a place to sleep that is safe and secure on our parking lot. We have cameras all over the place. We have a person who walks the lot at night and checks for who might be undesirable or code violators, or people who we have trespassed because, you know, they just don't behave. And so we do that. I don't, they've got the pictures, they can show you who they are, I can tell you who they are probably if I saw the vehicles. We have some in storage there right now, you know, and that is not illegal to store them. He told me that, you know, as long as it's not hooked up, that we can store them for a period of time, because we have church members who stay in homes. They bring their RVs down, we'll park them there, we'll keep till they get ready to go back home or travel someplace else, and they'll come back, get in and go. We did have some campers that came in. Of course they're going to if they see it's a free site. But I know of any of them that was disruptive to the flow of traffic or to the property, except for one case. In that case, I personally evicted them from the property. And it was not because of, it was not proper etiquette in using of the restrooms, okay? would be a way to put it. But folks, they were from France. They barely spoke English, and they didn't really know the difference. What I was trying to tell them, you can't go and whiz in the bushes. You got to go to the bathroom, you know? Well, one of my neighbors saw it, you know, and I said, oh my gosh, you got to be joking. And she came to me. And I told her, I says, you can't do that in the United States. We have proper places for you to go. It happened a second incident, and we asked them to leave. So, you know, we're just trying to help. If we don't have a place for these people to sleep in their cars, or people who are stranded, they're going to find other places on this beach which undesirable places for them to go, and at least they're safe where we're at. We're simply trying to provide a service, a sanctuary. And that's how we feel our property is. We are there to care for the people. We feed approximately 2,000 pounds of food a week to people in our facilities. They're not displaced people or homeless. A lot of them are bartenders, restaurant waitresses, and what have you, that just can't afford to live here and provide food for their families during the off season. And we provide food from there. We're FDA approved. We've jumped through every hoop we could find to get a status and approval. We have some RV there. He showed one of the other pictures, and it's been there for 7 years. And we fought it, I shouldn't say we fought it. We brought it before the town council 2 different occasions in the last 10 years. And I don't know if John's been here when we did one of those or not, but we had to prove to them that we had 3 sites on our property that were approved in the original building plans for campers to come and to go. And it was approved by the town. They said, no, it wasn't, so we have a book this thick. And we went through all that and had to show, you know, where it was at, and then it was, and we were left alone. Now, my son's not a rebel. He's not one looking to.
I don't think anybody's accusing him.
Well,
Well,
when they start putting all these code violations, we try to talk to them. You can't turn the water off and on when you have extended the invitation to people and you find out that you were in violation, which I still don't think we're in violation.
Right. So, and that's where I think the problem is going to be. I think that what the church is doing is commendable. I understand the intention behind it, but the town does have ordinances that have to be followed. I was happy when I heard that there had been a meeting as to how to go ahead and get the church to continue doing its work under the ordinances and rules for the town. But now when I hear you say that that you don't think you're in violation, that concerns me, because that sends me the signal that there's no intention on actually fixing the problem.
Oh no, we'll do what the town requested. We just don't feel like we were in violation. We're a church property. It's owned by the church. It's not an individual. And this is not a business that we're running. Harvest Host is free.
I understand that. I don't think, and the way, I have the ordinance in front of me. The ordinance doesn't make a distinction between when it's paid or not paid. The concern is that when you have a property that is not permitted to go ahead and accommodate the amount of vehicles that you're having as RVs in that property, that violates the code ordinances. Everybody that comes in through those doors with a code violation will always, so I'm not in violation. You were sitting here for a long time, you heard it. It's not the first time. And I understand sometimes a property owner might not think that there's a problem when there is, and that's why we have this, and I have the conversation. Yes, there is a violation. Let's work on getting corrected, okay? So, from the meeting, were you present at the meeting with the city? It doesn't sound like, right, with the town?
No, my son was.
Your son was?
Yeah, that's correct.
Okay. What has been, I guess, for lack of a better word, the proposal at this point in time moving forward?
I think that while I think that what the church is doing is, as an activity, is very commendable.
Absolutely.
And consistent with their what they believe to be their mission statement, and it's just running up against local government, the regulations. In reviewing the code section, while we've resolved some of the other issues, including the ability of the church to have what I would call 3 RV hookups, which are not the subject of this hearing.
Okay.
But there's pictures, I'm sorry, sir.
So what the issue is, and I think the special magistrate has properly identified it, is that right now, under our current regulations, new or expansion, and that's the word specifically used in our code, of RV parks or RV uses are actually prohibited. So in order to be able to conceivably even allow this to happen, it would require a change to the code.
Let me ask you this for the
Text amendment.
sake of being devil's advocate. Is the storage of the RV allowed?
Dead storage only, yes.
Pre-gen storage, okay. So here, and the reason that I mentioned that is I heard him mention that there are beds available at the property, part of the retreat.
Correct.
So maybe an option is for those, and again, I'm just giving suggestions. By any means, I don't have the right to dictate, or I'm just observing. That if the problem is people in the RVs, not the RV itself, if it's just getting parked, that perhaps they could have the RVs parked and the church provide them the sleeping accommodations in the structure itself in the retreat and use. And perhaps when you rent it out for the retreat, well, I guess you can't have the RVs there. Yeah. But when there's no retreat, then I guess that could be maybe a compromise that perhaps the city and the church can come into, where so long as it's being stored. And again, I don't do zoning.
Right. I mean, that's the.
I don't know if that's allowed by zoning. I'm just trying to figure out if that is a possibility. So.
But the zoning policy is that we are a 501c, okay, nonprofit organization, and that's what we have agreed to use the retreat center for the sake we're not a motel. We don't want to take money away from the hotels and motels.
Not by any means.
We don't want to take money from the Red Coconut for people coming in here. I've got a vehicle right now that is parked on our lot, and it's because that the place that they're staying at don't allow but one vehicle. They didn't have no place to put their vehicle, and it was from Miami. They were looking for, can we park here for a week? I said, yeah, we don't care, we got room.
So I'm guessing the church is not amenable then to go ahead and doing that? Because the part where there's a nonprofit or not, I get it's a church. It's obvious that it's a nonprofit. I mean,
exactly.
Like I said when I started, it's not a matter of whether you're charging or not charging. I mean, you can pay them to go ahead and be there. It doesn't matter.
I think that the issue with us, and I say us, the church or the church body or deacon body, is that whenever we got the codes, okay, we got the violation, and then we got the highlighted sections, and that was explained to me. It was, I said, well, You're saying I'm breaking the code for recreational vehicle subdivision. I don't have one of those. How can I be breaking the code on
Might
something I
think you
don't
have
have?
one of those, but the evidence presented shows that you do.
We
So
had to-
I am trying to work with you on a resolution because having our people parked in the church, in the RV, whether it's for one night, a week, it doesn't matter, it's not allowed. You can store the RVs there and allow them to stay in the
In the retreat.
in the retreat section if that is something they're amenable, and that accomplishes the church's goal. Again, if that is something that zoning would be able to work with or allowed or come to some type of resolution. I don't want to put you on the spot, but kind of did, sorry. But again, I'm trying to throw out ideas so that the church can continue doing its work while being in compliance with the code.
Oh, we've worked with them. I mean, the last time we worked with them,
All right, so I think there's a hiccup in my whole argument here, so let me go ahead and see that if maybe I can throw some more spaghetti on the wall and make it stick. Go ahead.
We just have to be really careful with, I don't know what their definition of retreat is, and it's not, you can come there and stay at the retreat randomly, or if they're only through events that they're having, or if that would be considered a short-term rental in some way, or, so, I mean, before we could say that, I'd have to look into that. And I'd
No,
have
I
to
know
look
it
into
does.
that.
Like I said,
We understand.
Yeah.
Those are just ideas out there that perhaps the city and the church can talk about and plug those holes in. Because let's say it's a short-term rental. Maybe they can come with some restrictions in regards to the short-term rental. They can go ahead and comply with those. I think there's an avenue there, perhaps, I'm not sure, but it's something that perhaps should be explored in order to allow them to be able to keep doing their work.
And another problem.
Without
with this
commitment, I
is
mean.
That we have continual complaints coming in from the neighbors that have these people. The one situation that he was talking about where there was a picture taken of somebody sleeping in the van, that wasn't a code officer that took that picture, that was the neighbor who was complaining on this. So the neighbor is complaining because you have these people that are there, and he's the one that's complaining that this is being used as an RV park, and it is a violation of our code. How to resolve that, where they can continue this, unless they are using the RV as dead storage, which is what the code says, I don't know that the RV can be on there unless it's being used as dead storage.
What does it mean as dead storage? Nobody in it?
Yeah, I understand.
That storage means that it's a storage facility. So the code allows for a property owner to store no more than one RV on their property for storage purposes. So I own a boat, I own an RV, I own cars. I can park my RV subject to certain requirements for purposes of storage.
But that would probably be for like a single family home. We're talking, I'm guessing.
Correct. So we're talking, it doesn't say, it's irrespective of zoning district, is the language in the code. It doesn't say that it's, that it just simply says that you can store one RV for storage purposes per property. What I believe you're talking about is that if they are operating a retreat, and it just so happens that the person who is coming to that retreat and occupy one of those beds is in an RV, they're just parking their RV while they're there for the retreat.
Well, I don't think, he says that when the retreats happen, they're typically from other organizations and they're rented out. So obviously, in that situation, then no RVs can be there.
Well, no RVs can be there, period. That's the problem. As it
But-
currently exists,
And I get it, but then we were talking about the storage, the possibility of the storage of RVs. So if there's and I don't have the ordinance or the code in front of me, if this is just,
I understand, and we can certainly have that discussion, but that's
and again,
not- that's not what's-
that's not what we are here for. I'm just trying to go ahead and try to see if there can be a compromise between the church's mission and what the city code is. So again, like I said, I'm literally throwing spaghetti at the wall to see something sticks, but I don't have the power to go ahead and tell the town, this is what you're gonna do, or no, we're gonna change I don't have the power to do that. I'm just
May
putting ideas out there that perhaps could be explored.
Madam Magistrate,
Yes.
may I read a statement? May I read a statement that may clear up a lot of things here?
So long as it's quick, because we've
It's
been on the
quick,
case
it's
now.
quick. Okay, it's very
All of
quick.
them have been long today, I'm so sorry.
The ability of people to simply stop in our parking lot and sleep in their cars while traveling through a direct ministry of the church.
Sir, I'm sorry. If I understand what the job is, the church is trying to do. That is just a restatement of what we already talked about. We really want to go ahead and wrap it up so that we can get the rest of the people out of here. Okay, so,
Just to summarize, if you look at the photographs that are associated with the citations, Special Magistrate, you'll see that they're RVs.
no, I get it. I think the
We're
evidence
not
is,
talking about someone coming and sleeping overnight in their car because they don't have somewhere else to stay. We're talking about people who have come to the site, have for all intents and purposes
I
stayed there for days, living out of their RV, and that's not allowed under our code.
I'm very clear on that. All right, now, my next question is for the town. Okay, so I see that we have, in the citations, there's 6 citations. The first one's for 250, the rest are 500. Okay, my first question is every citation per day, per RV, or how is?
Per violation.
Per day.
Per day.
So each citation is 1 day?
Yes. each
Okay.
That they went out.
Regardless of whether it was one RV or multiple RVs?
True.
Okay. And then I'm assuming that the 2 to 6 are being put at 500 as a repeat?
Correct.
Okay. For the sake of argument, if the church decides to go ahead and try to do some type of, what do you say, application or something in regards to zoning. Let me see, how do I say this? If the church wants to explore options on available potential ideas on how to come to a resolution to it, would it be an application done through zoning? Would it be an application done through,
They could, as the code is currently written, all our hands are significantly tied, including the town council. So, as I said before, I'm 99% sure that it would require a text amendment. There is a process by which third parties can apply to the town for a text amendment to the zoning code. Obviously that would also have to be determined whether or not it's also consistent with the comprehensive plan, if we could allow those types of uses. Ironically, and I want to give a great shout out and recognition to Mr. Kritzer. Mr. Kritzer is one of the members of our local planning agency and has been so for a number of years, so he's relatively familiar, more so than a lot of people, about what the process is, but it certainly would require at a bare minimum a public hearing before the LPA and 2 hearings before the town council for the adoption of an ordinance to modify the code and give everyone the opportunity to at least look at this issue.
okay, and the reason that I made the question is because part of my order will require obviously cease immediately, and that if he, until such time that there would be some type of resolution for that, and that he knows what the process or potential process would be to try to see if there can be some type of resolution. But it's,
Mr.
he
Kritzer.
probably knows that. Sounds like he knows it better than all of us put together.
Yeah, is more than welcome to and our doors are open to meet with him
Yeah.
and his son, and to look at ways that this particular use might be allowed and accommodated. Certainly we welcome the opportunity to have those conversations with him.
Okay. All right.
Can that conversation begin this afternoon?
Of course, I don't, I have a couple of other things, and I know with staff, but we'll get it, I would suggest that you schedule something with Jason and with Daphne at your convenience and at their availability. And obviously, to the extent that I need to be involved or get involved, then I'll obviously step in at that point as well.
And on the violations, I don't know that some of those pictures that you took, I mean, like one of the vans has been there for over a year, the brown one, like that was not a camper that was in there. You see what I'm saying? So
That's why I asked the question about how he went ahead and did the assessment about the citations. So he did it per day. So if you had 10 RVs on that day,
but I might have had one RV on that day, and it'd be that one that's there for storage. But I got, see what I'm saying? I'm just,
We're you know, for purposes of expediting the process, we're willing to reduce the requested fines to just $500, and we can then deal with total.
okay, so we'll do that.
okay.
All righty, I hereby find that the violation as stated in the notice of violation did exist. I'm hereby ordering the property owner to cease and desist from having the RVs at the property. I'm hereby doing a one-time fine for all the citations together for a total of $500. And I'm granting the city's requested amount of $75 in fees and costs as incurred by the city in bringing this matter before the magistrate. And obviously, no RVs at the property until such time there's a change, or that's my order. I don't even want to put that in there. That's it. So again, try to go ahead and see if you guys can go ahead and coordinate a meeting.
Payable within 30 days.
Yeah. Oh, payable within 30 days.
Thank you.
575. Thank you, and good luck. All right.
So, all right, let me look and see on number 14, Thomas, Gerace. Are they here? Then we're gonna move past that. B&B Properties of Fort Myers Beach, work without permit deck. All right, we're gonna do that next, which is gonna be number 13 was continued. Okay. They actually applied for a building permit, I believe. So, number 14 we'll hold till last because there is no respondent here. We'll move to number 15, which is B plus B Properties of Fort Myers Beach LLC. The violation is work without permit for a deck. The code officer presenting this is James Campbell. At the time, the town is requesting an order of violation, an immediate fine of $250, if that is all that we can do, because this case was open 8 months ago, and there's been no effort to obtain the permit. We request that you apply for a permit within 7 days, obtain the permit within 21 days, not including staff review time, a fine of $250 per day if not in compliance, and a $75 admin fee to be paid within 30 days.
Madam Special Magistrate, maybe in order to expedite the hearings, does the property owner contest the violation that a permit isn't required?
That what this one carries?
No, we don't.
Yeah, this one has the 5,000,
No, that was arbitrary. That was my
Oh.
immediate,
Oh,
because of how long the case has been open. So we've
had nothing-
knocked that down to 250.
What I would like to do is just explain that I was under the impression that a permit was not needed if there was damage to a railing or a gate or something like that after a named storm. I'm a property owner and live on the island. During Irma in 17, I had some extensive damages. And it was
You just speak into the
Then we need, no, then.
and it was a mayor, Sarita, Anita Sarita, that we didn't need a permit to fix this stuff.
let me go ahead, it sounds like we're gonna have.
All
to
right,
present. So what we're gonna do is, we're gonna present, he was trying to expedite it.
so I'm saying, now I realize I needed a permit.
Oh, okay.
They sent the stuff, I read it, I needed a permit.
Okay.
I think I'm here because we said we didn't respond. When in fact, we responded numerous times. I've sent, they made us get a drawing. We got drawings done. We presented the drawings. My contractor,
Has a permit been applied for?
I believe so, yes.
Okay.
We have the, an update.
Straight to it.
We have an update.
Okay.
I can give it to you. if you want.
They just confirmed that you had, that it was?
Yeah, we did.
Okay, so where is it at?
We just don't know where we're at this point.
That's why I'm asking. You're about to find out.
So, Madam Special Magistrate, part of the issue here is, that we've communicated with the property owner as recently as April of this year, sending them our standard letter saying what are the deficiencies in their application and what needs to be revised in order to have a compliant application so a permit can be issued. And we've had no response. That's why we're here.
So the permit has not been issued because there's some revisions that need to be done and they have not.
That's
been done.
correct.
That's correct. It was applied for, but it has not been issued.
Got it. Okay. So what is the holdup if you have it right there?
It looks like that a rejection letter was sent for fire. It looks like maybe it was an incomplete submittal for the application itself. We sent a rejection letter on 3/28 and another rejection letter on 4/12, which was the last that we have received anything.
Were those letters because of the same exact review request, or was it was in March, it was sent in, there was revisions, and then it had to be resubmitted again, and then on April, there was some more revisions?
And from what I'm looking at right here, it looks like it was on 12, the fire department wants more.
On 12/29/21, fire department required a resubmittal, reviewed for compliance, environmental review.
So environmental and zoning, flood, so it's like, looks like fire. The fire department is waiting for something.
We need fire.
So,
And then they sent 3/4 rejection letters, so they resubmitted for zoning.
but it's review for compliance.
And now we're waiting on the fire.
It looks like we're waiting for the fire department, which is something that we can't, that's,
So we're waiting on, on the fire department, or we're waiting on the property owner?
yeah, hold on, we're gonna find out exactly what it is. So,
Sorry, do we want to go ahead and table it and then keep moving?
where's she going?
So you're gonna pull up the permit, or
The
the,
permit.
Yeah, Madam Magistrate, let's just say that we need a complete permit. We need an answer to this within 7 days. And then if not, within 7 days, we need to have the resubmittal required.
My inclination right now is just to go ahead and give him 30 days to complete it, whichever
To
way.
finish it?
Yeah, to finish.
Okay,
it.
Yeah.
all right, that's good.
Because it's
Let's
a
just do
permit-
that.
Because it's a permit
And then
issue.
$250 a day after 7 days.
But there's,
We just need to know what else, so is the fire we're waiting?
Correct.
We're getting,
Correct. We're trying to
we're
find out
gonna
that
find that out, but we're moving this case along.
Fire is in a different issue. The fire department came to us and said we need to do some sprinkler work. And that has been done and approved and done with.
The fire department is a completely different
Yeah,
entity
This is the
than us.
first I've ever heard of the fire department.
it's part of the permit process. They're gonna have
So,
to,
we're just asking for 30 days, $250 a day after 30 days if it's not completed.
Can we show you some of these?
We're done,
it's,
if she wants to make the ruling.
I mean, if he wants to enter it into evidence, that's up to him, but it's not necessary.
yeah, so let me explain it in simpler terms. We have evidence, he was right. The permit that was applied for, there has been apparently 2 revisions done. So it was, give me revisions, you guys complied, send the revisions. It kicked back again, request for a second set of revisions. It sounds like, I'm not sure if it came back or it's, the holdup is with the fire department and the review, but it's still in review. So right now, your permit application is still in review. Once it gets completed through review, that's when, and it's approved by the town, they'll let you know, permit is ready. Okay, so then it's just a matter of coming up here, paying whatever you need to pay, and picking it up, and you're done. So right now, from your perspective, is that they're gonna tell you what the problem is, why it's on holdup, so that next submittal, if there's a next submittal, is compliant, and you can get your permit. So my order, what I'm thinking about doing is to give you 30 days for it to go whichever way it's gonna go, whether you have to go ahead and resubmit it, or they've already had it and they still have to finish the review. It's 30 days to go ahead and get it done.
And we will explain to you exactly where it is in the process.
Oh, there it is.
Could we
Right here.
schedule an actual meeting with somebody? Because
They got
Yeah,
your information here.
that's what that's.
Yeah, she's got the information that she got faster than I thought.
All right,
We're waiting on them now.
Okay, yeah, we're waiting on you to
Okay.
submit more plans, but we will set, I mean, you can, if you want, you can come out here and I'll help you right now.
That'd be great.
Yeah, let's go ahead and do that. Okay, so let me go ahead and enter my order, okay, real quick. All right, I hereby find that the violation as stated in the notice of violation did exist, continues to exist. I'm hereby ordering the property owner to come into compliance by obtaining the permit within 30 days, otherwise face a fine of $250 a day. This case was initially initiated in 2020, in October of 2021. There has been a delay in getting the case moving, in getting the compliance moving, and I'm granting the request from the city in the amount for a one-time fine of $250.
We waived that.
You'll waive that? Okay, so they waived it. So there you go. $75 in fees and costs, as incurred by the city in bringing this matter before the magistrate, payable within 30 days. So $75, that's it.
And then if you just walk right out there, as soon as I call the next case up, I'll come and help.
That'd be great.
Okay?
Thank you very much. Thank you very much.
Okay, the next case that we have, I believe, is going to be well, he's not here. So number 17 was continued. Number 18, Danks, Cynthia Marie Danks. No? Okay, number 19, Greg Leah Equity Trust Company. Do we have you here? Okay.
Aye.
And this is, the violation is a violation of section 1098, the registry of short-term vacation rentals is the failure to renew a short-term rental. The code officer is short-term rental specialist Kristen Schumacher. The town is asking for an order of violation to register the short-term rental within 7 days, a fine of $250 per day if not registered within 7 days, and a $75 admin fee to be paid within 30 days.
Proceed.
Oh, sorry. Ms. Schumacher, you've previously been sworn in, is that correct?
Yes.
And so has Officer Stout.
Yes.
And both of you are employed by the town of Fort Myers Beach.
Yes.
And Ms. Schumacher in particular, you are responsible for overseeing and enforcing the town's short-term rental regulations, is that correct?
Yes.
And you familiar with the property that's located at 430 Bonita Street?
Yes.
Can you please tell the special magistrate how you are so familiar?
Every year, we renew short-term rentals at the end of the year, and our short-term rental coordinator let me know, and Bill Stout, who is the code officer, that this specific property did not renew their short-term rental registration. I did include the code for it, and it says all dwellings and dwelling units need to be registered, and number 6, registrations shall be renewed annually. Registration fees, we don't need to register, but they need to be renewed annually. And as of when I looked 2 days ago, nothing has been renewed for this particular unit.
And the records that are indicate where this property is located and your research that are in the file and been submitted to the special magistrate for consideration?
Yes,
I'm going to ask you the same question I ask everyone. This can be done online, is that correct?
we can fill out the forms online and you just mail it in or email it in, and we can take payment online.
Okay, so this can be done within 24, 48 hours at the most?
Yes.
Okay. And this information is available to any applicant online?
Yes.
Nothing further.
All right, let me hear from you. State your name and relationship with the property.
Yes, hello, my name's Leah Gregg, and I am the owner of the property at 430 Bonita Street. I own it. It's not really a company. I just own it through a self-directed IRA. It's part of my retirement fund. Okay. But first, I just want to thank you and really the town in general for having ordinance and rules. I'm a big believer in rules and regulations, and I do follow the rules. I'm consider myself a rule follower. I lived here full-time since 2014. I purchased a legal duplex back then with the intent to live in the upper unit. And this is, I'm just going through an example of I have a couple properties here that I wanted to kind of share with you. I live in the upper unit.
So we can go ahead and.
Yeah, no problem. I live in the upper unit, I rent the lower unit, and that is registered by the town. Or actually, it's registered with the town for the short-term rental. In 2019, I purchased 2 additional short-term rentals. One is a condo, which I also have that registered, and the other is a home that on Bonita Street that is also registered. I submitted that registration last year, right when they were all due, paid them all at the same time. So the duplex, this is the one that's really in question, and this is really, I think, where the confusion is. What led me here today is that I paid 1 short-term rental fee for the duplex, and I was given a citation that stated failure to renew the short-term rental. So I was kind of confused on that because I did pay the short-term rental fee prior to being due. And when I inquired what the issue is, I was informed that since this is a duplex, I had to pay 2 fees, 1 per unit. So I did some research because I have a condo as well, and I know several other people that have condos, that short-term rental ordinances states that a condo or a timeshare unit, or a hotel for that matter, that's owned by a business can apply for an exemption from paying short-term rental fees per unit. So one building can have hundreds of units and they only pay 1 fee. So I sent an email to the council and the town manager asking, why would a single home with 1 parcel number have 2 units have to pay 2 fees? But you have like Estera Beach and Tennis Club, Diamond Head Resort. I mean, there's about 47 buildings that have applied for this exemption. Smuggler's Cove, Kona Beach Club, Tropical Shore, so on and so forth. They could submit an application and they can actually be exempt. So, I mean, technically it could be 1 building, just like my home is 1 building. They can have 374 units and they only pay 1 fee. But I have to pay 2, 1 for each unit. So when I inquired about that, the town manager answered me back and said that the council really makes the rules. They're the ones that just decide what the rules are and just make them with really no major rhyme or reason. But no one from council had answered me. So my question was, why can condo owners, co-op owners, and business owners be exempt from paying a short-term fee per unit, right? So in some cases, that could be 300, 400 fees versus a duplex that has to pay 2 fees. So when I did a little more research, I found that the only real rule to be exempt is to, it says, it lists in the ordinance that the only rule that provides an exemption is the HOA must implement the code of conduct in their building. And most HOAs, at least in the condos I have, they're not even on location supervising guests. And I personally manage my properties, so I make sure the code of conduct is there. I make sure all the rules are completed. I even make sure I go over personally and take out the recycle and the trash in and out so they're not sitting out. So again, I consider myself a rule follower. I didn't intend to break any rules here. I guess I'm still questioning why the fact that a condo or a timeshare or a hotel, whether it be owned by a business or an individual owner like me, can be exempt. Their building could be exempt, but a duplex that's 1 building can't be.
Well, this is the part, every hearing it happens.
Oh, does it?
So, no, not specifically that, but there's always a disclosure at some point in time when I have to go ahead and say, I don't make the rules, I have to take the evidence and the code as it's written and mesh them together and make a determination as to whether the violation existed of the code based on the evidence that's presented before me. I don't have the power to go ahead and question the council as to why they do what they do. All I can do is read the ordinance as written, whether I like it or not. My opinion doesn't matter. And I'm not saying I agree with you. I'm just saying that it doesn't matter whether I agree with it. I have to take the evidence and I have to take the code and mesh them together. I have the code in front of me right here, and there is an exemption for a specifically written exemption here for condo associations on the opt-out provision portion, which means it's been codified into it. There has been no codification whatsoever in regards to the duplex portion.
Right,
So
but
based on that, because I have to take the evidence and mesh it with the code, the way that the code is written, there is going to be in this duplex the requirement for 2 registrations.
Yeah, and that's fine. I mean, it's $500 or $50, I think, is what it was. Now I think it's probably $300 because it wasn't paid. It's late now. But okay, great. So that in the future, just moving forward, because again, I just feel like in a way it's kind of unfair to homeowners that want to adhere to the rules. So is that the best way to do it? Okay.
Not the proper forum.
Okay, perfect. That's what I will do. Okay, so what's next?
Okay, so now I go ahead and I'm going to order you to go ahead and register for that short-term rental within 7 days.
So I filled out the application, Bill, What more do you, I could take care of it right now. Just tell me, I already filled out an application. There's only one partial number.
You have
So,
one with you?
no, I have it. You should have it on record. I filled out 3 applications, one for each
You
property,
need a new one,
in January, or February, or December.
and you do lower unit.
Okay. Can we look at the one you have now, and I could see, I don't know if you have the upper or the lower registered.
I'll have you talk to Regina, once you're done, she'll
Okay.
walk out with you and she'll help you with that. She
Okay.
processes the registrations.
Okay, so for the record then, moving forward until perhaps anything would change, 2 units for 1 duplex, correct?
One payment per unit.
Okay, all right,
The property is 1 unit per unit.
okay, that's all I have.
Okay.
One
I hereby
time.
find that the violation as stated in the notice of violation did exist and continues to exist. I'm hereby ordering the property owner to come into compliance within 7 days. Otherwise, face a fine of $25 a day until the violations are corrected. And I don't think in previous ones we've done the one-time fee. This one's in May, so it wasn't like it was outstanding that long, so I'm not gonna do the one-time. But I am gonna assess the $75 in fees and costs as incurred by the city in bringing this matter before the magistrate. All right, that's payable within 30 days. All right, next one.
Okay, at this point, we can bring back that because the rest of the cases have no,
Respond, no, nobody's
Yes.
present here. Okay, all right.
so I meant to say.
Things flew away for a little bit here.
And it was Special Magistrate, we're calling back a case number 210301 slash 2022-0321, FMB Associates LPs. The respondent, I believe, the last was a request for an aerial photograph to kind of better orient ourselves on what took place.
Actually, yeah, I'm trying to go ahead and see that
Yeah.
sand dune. Thank you, yes.
So Chad Schutz, Town of Fort Myers Beach. What you see in front of you is an aerial, and then as you page through, you start with, I believe, 2019, 2020, 2021, and 2022 oblique views from the Lee County property appraiser.
Okay, give me the dates again, because I thought it would be in
So the first page, I believe, is a 2022
2022.
aerial. And if you see the white building that we were looking at before is that white building on the bottom right. And the, what I call a perpendicular dune is the
See that.
area where he scraped towards the beach. And then as you get to the wet sand, thereabouts is where the berm was created from that upland sand. And yeah, so 2019, 2020, 2021, and then 2022, usually taken in January of each of those years. So really, if you look at the 2021, the 2022 picture will be the only one was actually taken after the occurrence. Sorry, the 2022 aerial is the only one that,
No, I can see that one. I was more interested in the ones that were before.
sure.
And this happened in 2021, right?
Yes, ma'am. June 2021.
To the actual. Which agenda number was this one?
This is case 2020,
Agenda number.
4.
On the agenda,
Yeah.
number 4.
Number 4, yeah.
Okay, that's why it was hidden down here. There does seem to be there does seem to be a difference in the erosion, but it's not huge. In the, the elevation between the way that it was in 2019.
You know, we had storms blow through. It's gonna be, I would be surprised if you could tell, you know, after a storm comes through, and moves sand with water and erosion,
All right, so I think there was a degree of harm done initially to that area in reference to the sand dunes. I'll do this, let's see.
Yeah. What year is this? What year is this? What year is this?
I believe 2019, if you look at the
I think before we were talking about
magnifying glasses.
the 3-month, this is the 30-30, yeah. Okay,
And Special Magistrate?
yes.
For whatever it's worth, I bring your attention to the second and third photographs in the packet that you received that Mr. Schutz has handed out.
I split them up, so you're gonna have to give me the year.
It's the 2020 photograph, which you'll see from the aerial photograph, although it's a tad oblique, as Mr. Schutz stated, what I would call an emergent series of dunes. And then you look at the 2022 photograph, and they're no longer there. That's the damage. That area has all been scraped, and that emergent dune and that vegetation is no longer present. That can never be recovered.
No, I get it, but we've been over the whole issue about the vegetation. I've heard from testimony from the officers saying that there was some vegetation, but it was minor.
Yeah, it's a little bit of vegetation, and again, with the dune management plan, there has been a town policy of, after that renourishment event back in 2011, 2012, that, they maintain that vegetation in place. The issue is if we have everyone scraping the beach and depositing sand out into the Gulf, essentially, during sea turtle season, we're gonna have problems on the beach.
I get it. Okay. All right, I think I'm ready to go ahead and issue my ruling. And then we had talked about on this one that it was gonna take about, we were thinking 15 days to apply. Oh, no, we were talking about doing a meeting on July 8th, and then 30 days to go ahead and, no, but we were talking about the application for the meeting to happen next week on the 8th. And then there was the beat mitigation plan. I'm sorry, I'm crossing it over with the one with the wetlands, because they're both environmental, so they're crossing over a little bit. we were talking about the July 8th for the meeting, thereafter, 30 days to go ahead and submit documentation to go ahead and get it done, and then, why do I have 30-30? What was the process again? I'm gonna.
Your Honor, I think it was
yes.
30-30-15, which I think was.
That's what I'm looking, 30-30-15. What was that
to
again?
Submit, and
Okay.
then 30 days to get a response back from the state, and then 15 to actually take action on it, was my recollection.
No, I think because we were removing, no, that was the other one, see? Because the other one had, the state was basically saying they have no issue with it. Yours has, because it was them who brought it to our attention. So you gotta go ahead and get it resolved through the mitigation plan. Oh, that's right, submit it then to the state, get the state's blessing, then you can go ahead and come back here, submit it through there once they have the blessing for the 30 days, and then 15 days to go ahead and complete it on the premise that we were talking about, that it was pretty much just vegetation. Okay, alrighty, so.
If that's what they decide.
Yeah, again, like you said from the go, it's their choice. So we're just facilitating the timeframes and what's expected. But what ends up happening is obviously their choice. 100, and then we have, I think the request was 250. I think the per diem on this one requested was 250, right? Oh, there's no per diem on this one. So I'm gonna put 250, all right. And we have 30-30. Does that put us in August? I think it does, right?
What's that?
30-30. If we do 30-30-15, does that put us on the August hearing?
July, August, September.
No, you're in the, tomorrow's July 1st, so you got 30-30, and then the September would be like mid-September.
Okay, so it'll be, so then they get more time. So what I'm thinking about is bringing them back for status in August so that we know where they're at with, especially with the state, that everything's been submitted. It's not like and that way if there's a hiccup along the way, let's say for example, the state took 45 days instead of 30, then you'll be able to be locked in that hearing, and you can tell me, hey, listen, I need a little more time because this hiccup happened. And it also provides the town a feel for where you're at in the process. So that's my inclination right now, okay? All right. I hereby find that the violation, as stated in the notice of violation, did exist and continues to exist. I'm hereby ordering the town and the property owner, with representatives, whoever he wants to go ahead and do, but I have to put the town and the property owner to meet by next Friday to come up with the mitigation plan. And thereafter, I am granting the property owner 75 days to come into full compliance. And I'm not gonna break it up in pieces, again, because of the potential hiccups and deadlines. Failure to comply within that time frame will result in fines in the amount of $250 a day until the violations are corrected. I'm also granting the city's request in regards to the irreversible and irreparable harm, but instead of being $5,000, I'm gonna reduce it to $2,500. And I'm also granting the city's request in the amount of $75 for fees incurred, fees and costs incurred in bringing this matter before the magistrate. Okay? So you'll get an order. That's all payable within 30 days. Okay? All right, thank you. Oh, and add the status update on that August hearing, please.
Okay.
And obviously include in the order so she knows.
Is there a date set for that, or is it just the August hearing?
We are coordinating it right now, so we'll set the date. I think it's gonna be, I'm not sure. So,
I'm
yeah.
having them put it in the order.
Yeah,
That's
right.
the best way.
Yeah.
That way there's no confusion.
Yeah, we're coordinating it right now, so.
Okay.
Do you
Alright.
need a minute? We're down to just code officers now, if you need a
Like
minute.
three? I'm
Huh?
fine. It depends on
Okay,
you guys.
okay, let's move on then. We're going to number 16 now. Wilfredo Rodriguez, another common name that you've seen many times. This is a repeat of the weekly rental restrictions, section 342391 of the LDC. The code officers presenting this case is going to be Kristen Schumacher and Bill Stout. The town at this point is requesting, and it's an order of violation. This is a repeat offense, by the way. Again, immediately cease the weekly rentals a fine of $9,000, and you'll see in the attached calculation sheet, which Ms. Schumacher will explain. Admin fee of $50 and fines and fees to be paid within 30 days. Okay.
Ms. Schumacher, how are you? Please, you've been sworn in. You already testified that you're the short-term rental coordinator for the town of Fort Myers Beach. Can you please tell the special magistrate how you are familiar with this particular short-term rental located at 5765 Lauder Street?
This is going back years. This is a repeat violation. I'm sure you're familiar with this case.
Yep.
Mr. Rodriguez now has 2 units. He used to have an annual rental in one and then vacation rental in the bottom. Basically, to make this quick, I do have evidence of the cars, the rental calendars, and the reviews. And also, one of the big stacks is the complaints I get, and along with pictures and evidence to help me search. He did receive a notice of violation January 21st, 22. It was issued because we received a complaint. Because it's a repeat violation, compliance immediately. Then he received a notice of hearing for this hearing date.
Were both of those sent certified mail and or posted?
Yes, sent certified mail and regular mail. And I have the certified mail receipts as well.
I have them here.
Okay.
Alrighty, let the record reflect that I am reviewing the package submitted by the town, showing pictures of different days with different cars, evidencing short-term rentals of the property.
On the first page I submitted, I determined all the violations and made it easy from combining everything together, mostly with the reviews. You can easily see that, combining it with the cars.
And the total request is for the,
Total
stays 14.
So total, yeah, total stays is 14 per unit. In the upper unit, there were 10 violations out of the 4 months they had rentals. They were allowed 4 of them. Then the second one, total stays, the lower unit, they had 8 violations. They were allowed 1 rental per month, so January through June. So altogether, I found 18 violations at $500 per day.
Alrighty, hereby noted that there's nobody present on behalf of the property owner and that service has been established. I hereby find that the violation as stated in the notice of violation did exist and continues to exist, that this is a repeat violator, and as such, I am ordering the property owner to cease and desist immediately the short-term rentals at the property, both the upper unit and the lower unit. I am also granting the city's request for the fine of $9,000 based on the calculations of 10 violations for the upper unit, 8 violations for the lower unit, at the rate of $500 per violation on the basis that it's a repeat. That totals $9,000. I'm also granting the city's request in the amount of $75 in fees and costs incurred in bringing this matter before the magistrate, all of which shall be due and payable within 30 days. Okay.
Thank you.
Thank you.
Okay, next up is one of the new rock stars of the code enforcement show. He's been sitting patiently in there, back there waiting. Number 18, this is Code Officer John Encarnacio. This is his first presentation before.
Welcome.
Yes.
Thank you.
I'll be gentle.
Yeah, number 18. The property owner is Danks Cynthia Marie. This is a violation of the LDC Section 6111, adopting FBC 105.1, work without permit. This is the erection of a cheeky hut. The case number is 2022-0242. At this time, the town is requesting an order of violation, apply for the permit within 7 days. Obtain the permit within 21 days, not including staff review time. Fine of $250 per day if not in compliance, 75 admin fee to be paid within 30 days.
Officer, can you please state your full name for the record and welcome?
Certainly. John Encarnacio.
Officer Encarnacion, are you employed by the town of Fort Myers Beach?
I am.
In what capacity?
I'm a code enforcement officer.
In that capacity, is it your responsibility to enforce the town's codes and ordinances?
Yes, it is.
Are you familiar with the property that's located at 3324 Shell Mound Boulevard?
Yes, I am.
How are you so familiar? Please explain to the special magistrate and why we're here.
Certainly. On March 21st of this year, the town of Fort Myers Beach received a complaint from a neighbor in regards to a cheeky hut that was erected on the property of 3324 Shell Mound Boulevard. That complaint was assigned to me to investigate, and I made my way out there to begin my investigation.
And what did you discover when you were there? What did you see?
I made contact with the owner. I identified her as Cynthia Banks, and she was on the property as well as several other individuals. One of these individuals was the person who erected the cheeky hut. He was a Native American individual, and I explained to her the complaint that had come in, and Ms. Danks believed that she was exempt from having to obtain a building permit or any type of permitting because a Native American built the hut. At that point, I returned to the to Town Hall. I did some research, and I was advised that basically a tiki hut requires certain permitting. A cheeky hut requires an application, which involves some other paperwork that still has to be filed. So there is indeed some paperwork that needs to be approved by the town before the building of such structure.
But a permit fee, you can't. The town doesn't collect a fee. It's exempt, but a building permit is still required. Is that correct?
That is correct.
And did you inform the property owner of this?
Yes, I did. I actually returned to the property. I printed out the documents that are on the website. I presented those to Ms. Danks. I explained to her the process, told her to contact Town Hall if there was any questions or any issues, and I left it at that. I told her I'd check in, over the next week or two, just make sure that the paperwork had indeed been filed.
And to this date, or have you reviewed the town's records to determine whether a building permit application has ever been submitted for this particular cheeky hut?
I have, and the application had indeed been filed. However, there were certain documents that were not included, and it was returned, and Ms. Danks was advised that she had to submit a site survey and some other documentation in order for a permit to be issued.
And the requirements that Ms. Dansk was informed of is applied to and equally to all applications received by the town for cheeky hut construction?
That's correct.
And have we received, or has the town received a corrected permit application to this date?
No, we have not.
Have you had any further communications with the property owner?
On April 15th, I drafted a notice of violation, and that was posted on the property. It was sent to Ms. Danks by certified mail, and additionally, it was posted here at the town hall. In the meantime, in my travels, I had made contact with Ms. Danks, and she said she was getting it in, she was getting the documentation, so there was some follow-up. I believe it was on the 27th of April. I stopped in when I saw her vehicle there, and she stated that she had submitted the paperwork. I hadn't seen anything in the system at that point. She actually emailed me what she had submitted, and I told her that, okay, I'm gonna check it out, and that, you know, obviously, it has to go through the permitting process. It was at that time that, well, shortly thereafter, that the permitting process happened, and she was advised that, sorry, you didn't submit everything, there's additional documentation that's required.
And was a notice of violation and notice of hearing sent to Ms. Dance for today's hearing?
Yes, it was, and again, those items were sent certified mail, they were also posted on the property, and they're posted here at Town Hall.
Nothing further.
And this, that the town's requesting, total 7 days.
7 days.
7 days, 21 and 250.
Yeah.
If not in compliance per day. Okay. I hereby find that the violation as stated in the notice of violation did exist and continues to exist. I'm hereby ordering the property owner to come into compliance within 30 days. I'm not splitting it, it's 30 days. Otherwise, face a fine of $250 a day until the violation is corrected. I'm also granting the city's request in the amount of $75 as incurred by the city and bringing this matter before the magistrate, which shall be payable within 30 days.
Thank you, Special Magistrate.
Thank you.
Great job.
You're welcome.
Great job.
All right, I think we now is our last case, 14.
Yeah, I still show 13.
We have number 14, which is Thomas, Gerace. He has submitted some paperwork today, so that is going to be continued. We have number 17, which is Matthew and Tricia Oakley. That case number 20220305 has been continued. Then lastly, we have number 21, KLC Surf LLC. I have myself been in contact with the attorney representing this property owner as well as the engineer who is working on bringing what they need to do to bring the parking lot into compliance. So that is continued as well. And with that, we are finished.
Awesome. Well,
Thank you.
that was our agenda. Thank you so very much. Guess we'll see you in August.